Item number 44 for delivery order.
For reasons mentioned in the order, the interim bail granted to the petitioner is vacated and the anticipatory bail application is dismissed.
Item 45.
For reasons mentioned in the order, the interim bail granted to the petitioner by order dated 5/4/2024 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact.
My lord, one pending matter, my bail matter, since 2023. The person has been in jail my lord, for 1.5 years and he's suffering. There is some semblance treatment in the jail, my lord. But I want to move it urgently because he is to be taken outside.
When do you want?
If possible, today, my lord. A pending case, old case, bail matter. Yet two, my lord.
Today we will be rising earlier
Then any time after this motions and others.
at 2.
Yet two.
Meet with Lordship. At it about 27. Kindly adjourn the matter for the day. I am for the petitioner. Item 27.
Have you informed the other side?
Last night, not informed.
You have not informed.
Not informed.
You have to inform before making mention. First inform, then make mention.
I am not ready to.
Or wait till your turn. Wait till the matter is called. Before making mention, you have to inform the other side. Wait till we call the matter.
Hello, please.
May I please, Your Lordship, I beg to mention with the consent of the other side, Your Lordship, 9 and 10 to take place. In this matter, Your Lordship, some mutual understanding is going on, Your Lordship. So may I pray for listing the matter immediately after vacation, Your Lordship?
You have informed the other side.
Yes, Your Lordship, I have taken the consent.
What is your name?
K. Mira, Your Lordship.
Heard Mr. K. Mira, then counsel for the petitioner, who prays for an adjournment on the ground that some talk of settlement is going on between the parties. He also submits that he has informed the learned counsel for the other side, who does not have any objection. Considering the submissions made by learned counsel, let this matter be listed
Immediately after vacation, Your Lordship.
after summer vacation.
Till that interim.
No date. After vacation, the interim order shall continue till
Oblige,
next
Your
day.
Please, Your Lordship. Lordship, I beg to mention item number 35 for an upgradation. It's a part heard
35.
matter. Yeah. It's a part heard matter, Lordship. If Lordship may kindly take it up at 2. If that's not inconvenient for Lordship.
Okay, but 35, we will hear the matter we will hear the appeal instead of hearing the interlocutory application.
Okay.
Immediately after at 2, immediately after that bail unlisted matter.
Okay. Okay.
I'd like to mention item number 2, my lord. With your question, can it be on next Thursday, which day, any day, subject to your lordship's convenience? Because
Have you who is the other side?
it's the government, my lord.
Okay.
Washington petition.
You have informed.
Pending counsel, I have not informed, my lord.
You have to inform. Or otherwise 2 will be coming. Okay.
May I please, Your Lordship? Lordship, I'd like to mention item number 25.
Item number 25, yes.
And she has, Devasya Shekhar has received the paperwork already, so it may
Putul,
take up to 2 weeks.
Microphone কাম কৰি আছে নে? Yes, what do you want? Yes, item number 25. Which item?
25,
What do you want?
it may be adjourned for the day,
Why?
as she is not present here,
You're, okay. You are for?
Devasya Shekhar.
You are appearing for the amicus curiae.
Yeah,
What is your name?
Kanya Kumari Setiafar.
Heard Miss so-and-so, learned counsel appearing for the amicus curiae, who prays for an adjournment on the ground of personal difficulty of the learned amicus curiae. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
Yes, Mr. Rath. I'd like to mention item number 12, manager.
12,
I've taken the consent of the other side, manager.
yes. What is your prayer? You are for? What is your name? Heard Miss M. Sahu.
Interim may be continued. I am for the petition.
Heard Miss M. Sahu, learned counsel for the petitioner, learned counsel for the respondent, who prays for an adjournment on the ground that the conducting counsel for the respondent is out of station. Learned counsel for the petitioner does not opposes the prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks.
Interim may be continued.
The interim order shall continue till next date.
Again, Bill Lordships. I'd like to mention item number 40, man, 40. A matter is infraction of already instituted period is over.
40 is a criminal appeal.
Yes.
How it become infructuous?
15 matter. 10 years conviction. Already released from jail.
You are not pressing for the appeal. Because appeal does not become infructuous, even if it may be decided.
That's something is done and we will continue with that.
Okay, you do not want to pursue.
And we because it belongs to my lord Rajasthan man.
Heard Mr.
AM.
A.M. Ahmed, learned counsel for the appellant, who submits that the appellant does not want to pursue the instant criminal appeal as the appellant has served out the sentence imposed on him by the impugned judgment. Considering the how it will be disposed of as withdrawn. Considering the submissions made by learned counsel for the appellant, the appeal, this instant appeal stands closed.
May it please, your lordship? Lordship, I'd like to mention item number 18 and 19. On behalf of Mr. M. Holloy for CBI, lordship. Lordship, Mr. M. Holloy made with an accident and currently he is, the doctor advised him to take 7 days, at least 7 days bed rest. So he will not be available till 7 days, lordship.
18 and 19.
Yes, lordship. I have already taken consent from the other side.
Heard Miss
T. Begum.
T. Begum, learned counsel for the learned counsel submitting on behalf of Mr. M. Holloy, learned standing counsel, and learned special public prosecutor CBI, who prays for an adjournment on the ground that the special public prosecutor, Mr. M. Holloy, had met with an accident and is now undergoing his treatment. Considering the submissions made by learned counsel, you have.
I have taken consent already.
Okay. Learned counsel, this matter is adjourned for 2 weeks.
Yes. Obliged.
My lord, gentleman of item number 26 of the business.
26.
Yeah. In the office note, your lordship, continual dates are given where AD card has not received, yesterday AD has not received it. That's why I think it's in the orders today.
Now, why you want adjournment?
As reason that AD card awaited because of their, your lordship.
No, we'll pass orders when it is called. When the matter is called, we'll pass order.
Right, sir.
May it please, yes, my lord. My lord, with regard to item number 5, the matter has been wrongly listed. It was already admitted on 23/2023, my lord.
Item number 5,
5,
it will go to hearing column.
hearing column. It already admitted here. This will- So my lord, it will go to hearing column.
Is it? Learned counsel for both the sides, who submits that this matter has been wrongly listed in the admission column, as the matter has already been admitted. Let the registry shall list this matter in hearing column in due course.
DP office.
May I please, your lordship, I beg to mention item number 6, lordship, kindly adjourn the matter for today. I have already informed the others.
That may be fixed, madam. Stay there, madam.
When do you want?
Next week,
Any date after 20, madam.
What is your name?
P. Sarna,
You are for?
petition arranged.
Heard Ms. P. Sharma, learned counsel for the petitioner, who submits the, who prays for an adjournment. Mr. S. Rana, learned counsel for respondent number 1, consents to the said prayer. Date okay.
Lordship, interim may be kindly continued.
Let this matter be listed on 21/6/2024. The interim order shall continue till next day. Mr. Chaudhary,
Yes, sir, that's just matter.
today we are rising at.
Yeah, I know, that's why.
3:15, therefore
The matter could not be listed,
it
your
could
lord.
not be listed. So it will be listed within 2-3 days as per, it will be notified. Uh, Registry will list it shortly within a week or so,
Within this week itself.
if possible, because it is subject to that division bench.
No, Wednesday, I think there's not evidence by Wednesday.
I don't know. Registry will list it as soon as it is.
This district, if you have to indicate district.
I'll tell you.
DP. Item number 1.
None appears for the petitioner on call. Let this matter be listed after a week.
Item number 46.
Yes,
Madam, the other day I have submitted the bail granted to the co-accused, madam. That is there. Issue in this case is that, madam, that recovery which were made individual were clubbed together, madam, to make it a case of commercial quantity. Lordship will find the fire at page 14, madam.
page
Page 14,
14.
14, madam.
Yes.
Yes. Madam, may I just point out, there are some points, my lord.
What is your name?
My name is one is, my lord,
How many petitioners are there?
2 petitioners are there, my lord, in this case.
Who are they?
One is Muhammad Majrul, my lord,
Hmm.
and one is Muhammad Bijal. So from Majrul, my lord, if I may point out at page 14, clause number, point number 3, Lordship has got it, my lord, point 3. They chronologically listed that how much quantity has been recovered from the individual, my lord.
Okay.
Point 3, Lordship, one brown color backpack containing 2 numbers of packet of suspected to be ganja, weight 5 kgs each, total 10 kg, which is belonging to Muhammad Majrul. So that is petitioner number 1, my lord. he was first found with 10 kgs, my lord. And then lordship, it is clause number 6, serial number 6, my lord. One grey color backpack bag containing packets of suspected to be ganja packet weight 5 kg, total 5 kg. So from him, my lord, it is 15 kg only.
Okay.
Petitioner number 1. Now, my lord, coming to petitioner number 2, serial number 7, lordship, may kindly tell this for one mixed of red and grey color backpack bag containing 2 numbers of packet suspected to be ganja, each packet weight 5 kg, total 10 kg, which is belonging to Muhammad Bijal. That is petition number 2, my lord. And then, my lord, serial number 8. There also, my lord, from 2 bags, 10 kgs were found. So 10 and 20 kgs, my lord, from petitioner number 2, and 15 kgs was found from petitioner number 1. And to make it a commercial, my lord, they club together and show it as a commercial, my lord. So in my humble submission, my lord, there is no iota of material which suggests that, my lord, apart from traveling in this vehicle, my lord, there is any other material which suggests that there is abatement or conspiracy, my lord. And while dealing with the, my lord, other 2 co-accused, lordship has categorically found that thing, my lord, which has been reflected in that order also.
How many persons were traveling?
It's a tempo, my lord. 4 persons were arrested.
Or
4 persons.
yes, Mr. Sharma.
Yes, my lord, as far as my lord file is concerned, my lord, only did 4 witnesses, my lord, examined, PW witnesses.
Yes.
And my lord, IO is yet to be examined, my lord. And my lord, the PW2, my lord, that the driver, my lord, from the driver's statement, my lord, that only, my lord, that 4 persons are there, my lord, and along with them, my lord, the bags were recovered from them, my lord. Though, my lord, it is a magic vehicle, my lord, its capacity is more than that, my lord,
11.
but only that 4 persons are there, my lord, and there, 4 persons, my lord, these bags of, my lord, this contraband was recovered.
11, my lord, as per the instruction, there were 11 numbers of passengers in that magic vehicle. Paragraph 7, I have stated, my lord.
No, driver.
But only these 4 petitioners were arrested, my lord.
Whether there is any material to show that there was conspiracy amongst the. Because
My lord, they were all from Bihar, my lord. All persons, 4 persons, my lord.
apart from that,
My lord, kindly have a look at, my lord, the statement PW3, my lord. This is the driver's statement, my lord. In the petition, my lord, page number 46. 46. In the some reflection. They were boarded in that vehicle, my lord, together. On that day of incident, 4 passengers belonging to Bihar got to my magic vehicle and sat at the backside. They sat together with their bags.
where are you reading?
My lord, page 46, my lord, in a petition, my lord.
Yes.
That's the deposition of PW3, my lord.
Yes. Which portion you want?
My lord, first person, my lord. 1. Incident took place about a year back.
No,
at the-
which part you want to rely? Read it out.
The first part, my lord.
Read out.
My lord, on note, my lord, that incident took place about a year back at around 12 p.m., 2:30 and 3 p.m. at Wathaltuli Bazaar.
No, you want to rely that they sat together.
Yes,
their bags.
yes, my lord. On the day of incident, 4 persons belonging to Bihar got in my basic vehicle and sat at the backside. They sat together with their bags. After some time, police came and receiving information and checked the 8 bags carrying eight bags carried by those 4 passengers and found 15 packets. On
What
their-
do you want to say, Mr.?
Well, these
You sat together with other persons.
No, they were, my lord,
But on the material, what I believe, Lordship, is before this court is that prosecution stated that they are belonging to Bihar and they were traveling together. That much only, my lord. Apart from that, there is nothing. And when, my lord, these issues, my lord, topped up before the Lordship while dealing with the other 2 accused, my lord. Lordship's order is there, my lord. Paragraph 11 of the order may kindly be seen, my lord, for a moment. Paragraph 11 of the Lordship's.
Mr. Sharma,
my lord.
apart from fact that they were traveling together, no other materials. Contraband was found with them.
Yes, my lord. The
Individual-
police recovered it, my lord. They, my lord, stated in the FIR, my lord, is separately. But they were together, my lord. And from them, my lord, and bags were also with them, my lord. So, my lord, though it is recovered separately, my lord, but conscious possession is there, my lord. They know each other, my lord.
No,
They
they may
belongs
be
to, my lord.
tried, but whether they can be tried for possessing commercial quantity, that is the question.
That is difficult, my lord. Some little.
Heard Mr. M.H. Chaudhary, M.H. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor for the state. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Muhammad Mazrul and Muhammad Bizal, who are detained behind the bars since 25/8/2022 for last,
For last 655 days, my lord.
within bracket, for last 655
5 days.
days in connection with special NDPS case number 121/2022 corresponding to Bajari Chera PS case number 156/2022. The gist of accusation, quote from bail application number 2824/23, 2824/2023, quote para 3. Learned counsel for the petitioner has submitted that how many days it comes?
It's, my lord, 655 days, my lord.
In years, how
Yeah.
much?
1 year, 9 months, 16 days, as on today, my lord.
Learned counsel for the petitioner has submitted that though the petitioners have been detained behind the bars for last 1 year, 9 months, 16 days. However, the trial against them is still to culminate. And stop. It is also submitted that It is also submitted by learned counsel for the petitioners that though the contraband seized from the petitioners were from their individual capacity and where is the FIR?
FIR page 14, my lord.
And from perusal of the FIR itself, it would appear that the quantity of contraband seized from the petitioner number 1, Muhammad Mazrul, was 15 kg in total. And quantity of contraband seized from the petitioner number 2, namely Muhammad Rizal, was 20 kg in total. And it is submitted by learned counsel for the petitioner that both the quantities are below the quantity required for ganja to be considered as a commercial quantity. And therefore, he has prayed that considering the quantity of the contraband seized as well as period of detention undergone by the petitioners, they may be allowed to go on bail. Learned counsel for the petitioners has also submitted that on the same ground, 2 other accused persons, namely Pawan Kumar Yadav and Sanoj Kumar, who were also arrested in connection with the said case along with the above named petitioners, have already been granted bail by this court by order dated 3/4/2024 in bail application number 2824/2023. Quote para 5 from the bail order. Quote para 6, 7. On the other hand, Mr. P. Sharma, learned additional public prosecutor, has opposed the grant of bail to the present petitioners on the ground that all the 4 accused persons who were arrested in this case were found together in the magic vehicle bearing registration number AS 11 AC 2925, and all were from Bihar and were going to Bihar from Patharkandi. And if the total quantity of contraband seized from all of them is considered, it would come to 73 kgs, which is much more than commercial quantity. And therefore, he submits that embargo of section 37 of the NDPS Act is applicable in this case. Quote para 9, para 10. Para 11 changes. What is like 11, 12, 13. The petitioners are allowed to, both the petitioners are allowed to go on bail of rupees 50,000 each
some stringent condition.
with certain conditions. With 2 sureties.
One, my lord,
One of
local
the
surety,
surety may be a local surety.
Because they are belongs to Bihar, my lord.
Local surety with certain conditions I can take it on. With above observations, this bail application is hereby disposed of.
Deeply obliged.
Amita, para 12 of changes I will make those changes.
Yeah, please, your lordship, after the lordship record was called for, lordship. Probably record not proceed.
Record is,
One office note is there, madam. I would not go through it. Yes, office note, Ajay. Sorry.
record has not yet been, we will issue reminder.
Lordship,
Heard Mr.
my name is not there, lordship. I on behalf of HRA.
What is your name? I
Ayu
forgot.
Chaudhary, lordship.
I.S. Chaudhary.
Ayu
Ayu Chaudhary. Appearing on behalf of
HRA Chaudhary.
H.R.A. Chaudhary. Learned Senior Counsel for the petitioner. Also heard Mr. D. Das, Learned Additional Public Prosecutor. It appears from office note dated 7/6/2024 that the scanned copy of the case record of NDPS case number 35/2023 along with the scanned copy of case diary of Bajari Chera PS case number 83/2023, which was called for by order dated 24/5/2024 has not yet been received. Registry shall issue reminder for the scanned copy. Let this case be listed after when? Let this case be listed on 25 June.
24. Obliged. Case there is there.
Item number 16.
What is to be done after?
No, no, yes.
Written, no.
Let's wait for some time. Is there is there, otherwise,
Okay.
if it is adjourned again, madam.
Call after something.
Lordship, my seniors on legs, Lordship, can you adjourn the matter for today?
For the,
For today, he's on legs, Lordship.
Lordship, we have not received the full instructions, so kindly grant us time.
the counsel for both the sides prays for an adjournment on different grounds. Considering the submissions made by learned counsels, the prayer is allowed. Let this matter be listed after 2 weeks.
Obliged, my lordship.
May I please? This is relating matter related to NIA. My complaint petition has been dismissed because the learned trial court held that the complainant failed to prove his case, my lord. The learned trial court held and some collateral incidents which is not applicable in this case. my lord.
Whether the notice on respondent number 2
I have
has,
appealed, lordship.
you have,
Yeah, clear. Two, lordship.
you were acquitted.
Acquitted, lordship.
Now what is your prayer?
Lordship.
We will admit this appeal and fix it for hearing.
Report hearing, but lordship, there's not enforceable debt, lordship. I have issued check. There is no dispute, lordship, but there was not legally enforceable debt, lordship. He promised me verbally to provide me one JCB, lordship, then I issued check. That is post-dated check, lordship.
Know what you propose to hear the matter.
Yeah, lordship. Actually, hearing, lordship.
What is your submission?
My lord, the complainant successfully proved the case, my lords. One JCB, my lord. The accused is taken around rand, my lord. Check is proof, my lord. Only his person, my lord. This the learned trial court under DW1, which is not the
Where is the impugn order?
impugn order, my lord. Page, my lord.
Page 13.
My lord, it starts from 15. And operative part starts from, my lord, '25, my lord. 25, page 25, last bottom from bottom third line, my lord. Operative. The doctrine of reverse burden introduced by section 139 NIX should be balanced, my lord.
Where are you reading?
My
Page
lord,
25.
Page
Yes,
25
yes.
from the bottom, my lord, from the bottom to the third line up, my lord.
Yes.
The doctrine of reverse burden introduced by section 139 of the NIX should be balanced. In the case in hand, it is seen that accused has adduced evidence, Ramdas Valmiki as DW1. My lord,
Yes.
my lord. To establish that the check in question was delivered to the complainant for lending him as excavator, but that the same was not never delivered to him by the complainant. DW has deposed the same in his evidence by stating that the complainant had never handed over or lent any excavator to the accused, A1 for the work, and that the complainant had also not returned the check in question. The complainant had also failed to bring the case as how, when, where the excavator handed over to accused number A1, accused A1. Even if it is believed the excavator handed over to the accused, the complainant has failed to prove as where the accused has used for it, my lord. Only basis of that, where, how used the excavator, my lord. Check is already proved, my lord. He admitted the check, my lord. Signature also admitted. But the learned court below held that where, how it is excavator is used, my lord. Only on that point, my lord. It's totally, if he has any claim, he must have filed any civil suit, my lord. The complainant successfully proved his burden, my lord. But the learned court will erroneously, my lord, shifted the burden to the complainant, my lord.
No, read the paragraph completely.
My lord, my lord. The complainant has also failed to bring his case how, when, where the excavator was handed over to the accused, A1. Even if it is to believe that the excavator was handed over to the accused, the complainant has failed to prove as where the accused has used for it. There is no and documentary evidence which the complainant has produced or exhibited to prove that any excavator was given to the accused by him. The complainant has also failed to prove as to from where he got the excavator or that he is the owner of the excavator. Excavator are heavy construction equipment consisting of a boom, dipper, bucket, and cap on a rotating platform known as the house. The house sits atop on undercarriage with tracks or wheel. They are a natural progression from the steam shovel and often mistakenly called power shovel. In addition to digging, excavator are commonly used for projects such as demolition, dragging, river, material handling, or just simply heavy lifting objects. The complainant has completely failed to bring as where the accused used such big machine. That is the excavator. The accused side has not denied that the check is question was not given to complainant. It is there, already admitted, my lord. The accused A1 has successfully brought out the complainant has failed to deliver the agreement. Only the trial court held that the accused, the complainant failed to deliver the, my lord. Check amount for probe, he has received a legal notice, etc. All the ingredients, my lord. Next 16, my lord. Next 16 para below. Taking into account discussion made herein above, in its entirety, it appears me that the complainant has not been able to discharge his burden, prove that accused A1 issued the check in discharge of any debt or liability towards the complainant, my lord.
How have you proved your he issued the check?
Yes,
You-
my lord. The
any
complainant adduced
charge
evidence,
of
my lord. He was cross-examined thoroughly by the accused, my lord. My lord. The accused has not come forward to repose his evidence. Only one friend, my lord, who DW1, who is his friend, my lord. He himself stated he does not know whether check and my lord. He only hear from the accused persons, my lord, DW1, my lord, especially stated that the check was not returned, my lord.
No, how you have discharged your liability,
The
your
liability,
your
my lord,
burden that the
Right.
check was issued in discharge of a debt.
My lord, I have successfully discharged my liability by proving giving evidence, my lord. The PW was cross-examination, my lord. Check was proved, my lord. Check, he admitted his, my lord, a check in the 330 statement, my lord. Signature also proved, my lord.
No, mere issuance of check is not enough.
Hello.
The respondent was acquitted only because you failed to discharge the burden that check was issued
Yes,
in discharge of a.
yes. Legally
He is
enforceable.
on
Legally
his
enforced.
person, my lord. He has not adduced any evidence, my lord, that I have not been done. My person is that he have taken rent the excavator from me, my lord, on the basis of the check was issued, my lord, for the rent once, for the rent of rupees.
Page 19, lordship. One
160.
Ramdas Valmiki, lordship.
No, let him finish.
My lord. On the basis of this rent, my lord, 1,60,000 rupees, he issued the check, my lord. Thereafter check was deposited, my lord, that was dishonored due to insufficient of funds, my lord. Thereafter, my lord, notice was issued. After notice was issued, received the notice, he denied the same, my lord, without any reply, giving notice, my lord. Reply to the legal notice, my lord. And he himself not come to the learned trial court to depose his person, my lord. DW1, one of the friend, my lord, his. DW1 himself also said that at that 11th time, he was not there, my lord. He was in Nagaland, my lord. He was working DW1 for depose evidence, my lord. Enter here, my lord. DW1, may I, lordship, may I DW1, cross of the page 19, my lord. Paragraph 3, my lord, or 6, my lord.
Yes.
DW1 Ramdas Valmiki, in course of his deposition, has stated that he knows the accused, he knows that complainant Raju De, PW used to rent excavator. It is admitted, my lord, JCB, etc. Accused Gauri Dirial needed excavator machine for his work. Gauri told the DW about the same and told him that Raju De rents such machine and would arrange a talk with PW1. He accordingly arranged a machine of Gauri Dirial with Raju and asked him advance for rent of receiving an excavator amount rupees 1,63,000 and rupees 3 lakh respectively. PW1 asked Gauri Dirial to issue checks, and when Gauri asked in whose name the check would be issued, when Raju said that there was no requirement of mentioning any name and Raju told Gauri that he would mention the name and date of the person of whose recipe or excavator would be given on rent. Accordingly,
What
Gauri
was
did
the amount, check amount?
1,60,000 rupees.
Okay.
But they stated that 2 checks were given, my lord. Different version they have taken, my lord. Accordingly, Gauri Dirial issued 2 checks. Raju did. This transaction took place in the December 2017. That the complainant told the accused that he would arrange excavator and JCB machine within 1 month of receiving the check. Gauri Dirial did not receive any excavator and JCB even after expiry of 1 month. And Gauri told him that Raju went to Delhi for some maternal medical purpose, so the JCB and excavator was not given to him. So far, he knows.
No,
Gauri Dirial.
that the respondent owes you a debt. You have shown by your oral evidence, only oral evidence of PW1. Apart from oral evidence, nothing is there.
Oral evidence for on that part, there is
Oral
nothing.
evidence of
Oral
PW1,
evidence,
which the trial court did not rely upon.
my lord.
So where the trial court erred, why trial court is wrong? What is your submission?
Particularly wrong, my lord. I successfully discharged my burden. Check amount, the legally enforceable debt, the instrument which is he given, unless there is, my lord, near transaction, he would not have give the check amount, my lord. On that part, he failed to discharge his liability, my lord.
Okay.
Instrument was given for the purpose of rent, my lord. Only one person, Sir Raju, he himself not come, my lord, to depose, my lord. Another person, my lord. The complainant has no opportunity to come as cross-examination the accused person, my lord. Whereas the complainant himself adduced evidence, he was thoroughly cross-examined, my lord. He stay away from the witness box, my lord, the accused person, my lord. Only he stated that he has not received the excavator for his use, my lord. Learned Taiko held that I have not proved my ownership, my lord. Ownership is not necessary, my lord. Instrument is necessary, my lord. I have successfully proved the instrument, my lord. Check, and he admitted, my lord, 330 statement. Only his statement is that I have not given him the excavator. Whether I have given or not, this is code of, he can put question through the civil court, my lord.
Okay, yes. What is
Lordship.
it?
Page 20, lordship. Next part, lordship. The accused issued 2 checks to Raju De, lordship.
Page,
This transaction took place December 17, and then after that, he went to Delhi. He does not know whether they returned check 2 checks or not. Actually, lordship, I have given 2 checks, lordship.
okay.
Yes, sir. Verbally, he told me that he will give me the JCB, lordship. He did not provide me, lordship. 2 checks I have given. He told that no need to mention the date and name, lordship. 1 check,
Your
lordship.
plea is that though you issued check,
Yes, I have not.
he
received-
did not
yes.
handed over JCB to
Yes,
you.
yes. And lordship, whatever 2 check, lordship. This 1 check, 1,60,000, lordship. This case, lordship, item number 3. And next case, lordship, he planned a manner on another person. Get item number 5, lordship. I do not know him, lordship, even. He filed case against me, lordship. Same story. Item number 5, that already admitted, lordship. Item number 5. 5. Yes, item 9. Oh. Page 21, lordship, 313 statement, lordship.
No, what is your submission that
There's no legally enforceable debt, lordship. It is a post-dated check, lordship.
that you did not adduce your evidence?
The defense evidence are there, lordship. DW1, page 19. Yes. He the mediator, lordship. He introduced Raju with me, lordship. He know everything, lordship.
Heard, learned. Heard Mr. U Das, learned counsel for the appellant. Also heard Mr.
This way, lordship.
D. Circle, learned counsel for the sole respondent. The hearing concluded, judgment reserved. And whether the item number 5 is
5.
similar?
Similar, lordship, but that's admitted for hearing, lordship.
I am not here.
Yes.
I have no
Other
knowledge,
counsel is there.
my lord. Never was.
Fixed point of the top. Hearing part.
To item 3 is.
I have no relation.
Lordship,
with
one
that
prayer,
case,
my
lordship.
lord. I have also not.
Only fix both the cases altogether, lordship.
No.
It's connected, lordship.
I queried you whether to hear it or not. You should have made this prayer after hearing. This will be,
Indefinitely, my lord.
okay,
Obliged.
judgment reserved in this case.
Obliged.
May please, your lordship.
Yes, Mr. Bhattacharya. What is the matter?
My lord, I have come for the quashing.
And I
I've come for the quashing of the process as well as the entire order of taking cognizance. Because, my lord, there is certain rules to take the cognizance.
Whether interim order has been passed?
Yes, my lord. Further proceeding state. It will take time, my lord, to hear this law points involved in these cases.
Okay, then what
The
you
date
propose?
Admitted and fix it a date, my lord, for hearing.
Is it okay?
The case is in the state of DW, my lord.
We'll No, case is going on.
No,
It is
no,
stayed.
it was
stay.
there.
We'll fix, give a fixed date for hearing. Heard Mr. K. Bhattacharjee, learned counsel for the petitioner. Also heard Mr. What is it?
CS,
C.S.
right.
Rai, learned counsel for this sole respondent. The scan copy of the trial court records have already been received. Let this case be listed. Let this criminal petition is admitted for hearing. Learned counsel for the respondent has submitted that by order dated 23/5/2023, by order dated 4/5/2023, the further proceeding of CR case number 1106/2015 has already been stayed, hence an early date may be fixed for the hearing. Considering the submissions made by learned counsel, registry to fix this case, list this case for hearing on, when do you want?
30th July,
Okay, 30 July
30th July.
2024.
Obliged.
Yes.
My lord, this is appeal, my lord, regular appeal. It was admitted, my lord, and accused before your lordship was granted interim bail pending disposal of the appeal.
Why it has
But-
come for admission again?
But it is wrongly, my lord, actually it is regarding notice upon the respondent, my lord. Appeal out of, my lord, POCSO Act.
Then
Therefore,
it should have come in orders column only.
yes, my lord. Nevertheless, my lord, the service was, my lord, lordship kindly, my lord, office note dated 1/6/2024, my lord.
Appeal has been already admitted.
Admitted, my lord, on 11/9/2023.
Have you taken steps for
Yes, my lord.
issuance of notice?
Yes, my lordship, office note dated 1/6/2024 is relevant.
Okay. Yes, Mr. Das. This is a POCSO matter. So though the AD card has returned back with signatures of respondent number 2, then whether we have to wait till the report from the jurisdictional OC.
Promise.
Okay.
Let it come some other day.
Okay, none appears for the petitioners on call. Let this matter be listed after 2 weeks.
Lordship, my senior is legal and another court, kindly maybe allow for timing.
For the time being,
Yes.
okay.
I think, my lord, for the time being, I'm making a prayer for adjournment for the timing, my lord.
May it please your lordship. Lordship, petitioner before your lordship is a company registered, my lord, which has been made an accused in the complaint case, my lord. Lordship will find the complaint case at page number 25. Page number 25, lordship.
Both sides are, appearance is complete.
Lordship. Complaint is also.
I am for the respondent number 2, Lordship. Lordship, in this case, Lordship, after filing this CR case before the learned court, Jorhat, the complainant before that learned court has now want to withdraw this CR case. But in the meantime, but this Honorable High Court already stayed this matter. So therefore, the learned court below did not allow to withdraw the case or withdraw the CR case. So then this is my instruction. So if the court allow to withdraw the case in the court below, then this case will be infructuous then.
Let them withdraw.
Lordship.
Heard Mr.
My name is T. Kolita, Lordship.
Heard Mr.
T. Kolita.
T. Kolita, learned counsel for the petitioner. Also heard Mr.
SRA Nasir.
S.R.A. Nasir, learned counsel for respondent number 2.
Withdraw কৰিলে ইয়াৰ পৰা withdraw কৰি তলৰ কেছটো তলত withdraw কৰিলে infructuous হৈ যাব।
You are the.
I'm for the
you are
respondent
the-
number 2.
No, respond, who is appearing for respondent number 1?
State.
Okay. Respondent number 2. Learned counsel for respondent number 2 has submitted that the who is the complainant? Respondent number 2 is the complainant.
Lordship.
That respondent number 2 who had filed the complaint case number. What is the complaint case number?
133, CR 133, 2023.
CR case number 133/2023 pending before the Court of Learned Judicial Magistrate First Class is willing to withdraw the said case, which is said case before from the trial court. However, when the respondent number 2 approached before the trial court for withdrawing the said case, it was informed to him that as the further proceeding of the said case has been stayed by order dated 16/8/2023 passed by this court, the prayer for withdrawal was not allowed.
Lordship.
The learned counsel for the respondent number 2 makes praise for allowing the respondent number 2 to withdraw the case from the learned trial court. Stop. Learned counsel for the petitioner does not have any objection to the said prayer. In view of submissions made by learned counsel for the parties, it is hereby made clear that the pendency of this criminal petition before this court or the operation of stay order granted by order dated operation of stay granted by order dated 16/8/2023 by this court in this case would not be a bar for the respondent number 2 to withdraw the CR case number 133/2023 if he wishes to do so. Let this case be listed again after 2 weeks. In the meanwhile, you may proceed.
Lordship. After vacation, Lordship.
After 4 weeks.
After 4 weeks.
That means after vacation, Lordship.
After vacation.
Lordship, may I pray for fixing a date, Lordship?
Let this case be listed again on 25th July. 25th. 25th July. 18 July.
18 July.
18 July. In the meanwhile, the respondent number 2 may approach the trial court for withdrawal of the CR case, comma, if so advised.
And Lordship, they will produce the order copy if it is allowed. They will produce the order copy of the trial court, Lordship.
Withdrawal order. on
Withdrawal
the
order.
basis- No, unless they withdraw, unless they produce it, this case will continue.
Lordship.
Lordship. High level.
Much.
Item 50.
None appears for the appellant on call. List this matter after 2 weeks.
Orders, item 17.
My lord, as per dated 17/5/2000, notice is deemed to be served. The matter may be listed for hearing.
Office order dated,
Dated 17/5/2019.
heard Mr. What is your name?
P. Hazarika.
Heard Mr. P. Hajorika, learned counsel for the appellant. Also heard Mr. D. Das, learned additional public prosecutor. Which office note you are referring to? Which office order?
Office order as per order of the court dated 17/5/2000.
Okay. Okay. It appears from order dated 17/5/2019 that the notices against the respondents, notices issued to the respondent number 2 has been duly served, has been deemed to be served, and this case was directed to be listed for hearing in due course. It appears that this case has been listed wrongly under order columns. Let this matter be listed for hearing after 2 weeks.
Item 20.
I am to respondent number 2, Lord.
What is this?
This is appeal against acquittal, Lordship.
Whether appeal has been admitted?
Not admitted, Lordship.
Who is for the appellant?
Lordship. Petitioner is not appear, Lordship.
None appears for the appellant on call. Mr.
B. Borgohain,
B.
for respondent
Borgohain.
number 2.
B. Borgohain appears for respondent number 2. Mr. D. Das appears for the state respondent number 1. As the counsel for the appellant is absent, let this matter be listed after 2 weeks.
Much obliged.
Item 21.
My pleasure, Lordship. As per office noted, service was not completed, respondent number C. Your Honor, may take fresh step upon respondent number 3.
Mr. You are for?
I'm for respondent number 2, Your Honor.
This is item number 21. Heard Mr. A.T. Sarkar.
S. Hussain on behalf of A.T. Sharkar.
Heard Mr. S. Hussain. appearing on behalf of Mr. A.T. Sarkar. Also heard Mr. A. Chaudhary, appearing for respondent number 2. It appears from which office note you are referring to?
27/8/2022, I think.
After that, there is. As per office note dated 2012-2023, it appears that the notices issued to respondent number 3 has returned with an endorsement that addressee cannot be located in the address given. Stop. Learned counsel for the appellant has, learned counsel for the petitioner has submitted that the petitioner may be afforded another chance to take fresh steps. Do you have any other address?
I think
You have to
We
find out.
we have addressed.
Fresh steps on respondent number 3. The prayer is allowed. The petitioner shall take steps for issuance of notice on respondent number 3 at his proper address by registered post with ADs within a period of 3 days from the date of this order, returnable after 4 weeks. Let this matter be listed accordingly.
I'm sorry, Lordship. Item 20, I was supposed to appear, but the learned counsel appearing for the respondent has informed us that they will take adjournment. That is why Lordship in another court. Lordship. So Lordship may record our presence only. Lordship may adjourn the matter.
Okay, item number 20, presence.
May I please, Lordship, as per office note dated 28/5/24, services await Lordship.
What to do?
We will take fresh steps.
Heard Miss
C. Chaudhary
C.
on
Chaudhary.
behalf of A.N. Bora.
Heard Miss C. Chaudhary appearing on behalf of Mr. A. M. Bora, learned counsel for the petitioner. On perusal of the office note dated 28/5/2024, it appears that neither AD card nor the unserved notice has been received back by the registry. Learned counsel for the petitioner prays for allowing the petitioner to take fresh steps on the respondent number 2. The prayer is allowed. The petitioner shall take fresh steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks.
Plus,
List accordingly.
May I please, Your Lordship? Lordship, as per office note dated 13/5/24, my lord, notice has duly been served to the respondent, my lord.
How many respondents were there?
On 2 respondents state on the informant, my lord.
Putul, AD cards, no?
Yes, sir.
What is the name of the respondent number 2?
My lord,
Angad Hajarika.
my lord.
Heard Mr. A.K. Jain.
SK.
Sorry. Heard Mr. S. K. Jain, learned counsel for the petitioner. State is also there.
My lord.
Also heard Mr. D. Das, learned additional public prosecutor. It appears from office note dated 13/5/2024 that the AD card issued to the respondent number 2 has been received back with the signatures of the respondent number 2 thereon. Stop. The notice on respondent number 2 is deemed to be duly served. Let this case be listed. When do you want?
Normal course, my lord.
In admission columns
Yes.
or for
Appeal, my lord,
appeal,
already
okay.
admitted.
Let this case be listed for hearing in due course.
My lord. Obliged.
Please, my lord. Well, it's an appeal against a judgment and order.
Why it has come in orders column?
My lord, perhaps pursuant to the order, judgment passed in Deepak Nayak, my lord, perhaps informant and victim is, their presence is required, before hearing of the appeal, my lord.
This is a POXO matter.
Yes, my lord. Convicted under section 6 of POCSO.
Then you take steps.
My lord.
Take steps for issuance of notice to
Yes,
the
we have been appointed as an amicus curiae, my lord.
358 days.
My lord, my senior advocate could not appear today, my lord. So the matter will be adjourned for the day.
But already 358 days delay is there.
Your not, lordship, okay, left it is
Okay,
400,
let us senior also
480 days.
heard Mr. K. Bhuya,
Yes.
learned counsel for the petitioner.
My
Also heard Mr.
lord, if possible, after 2 weeks.
What is your name?
Miss M. Khatun,
Who is your senior?
Mr. S. Ahmed, respondent number 2.
Also heard Miss M. Khatun, who submits that her senior, why he could not appear?
His illness.
Due to his illness, is unable to appear before the court today. And on the said ground, she prays for an adjournment. Learned counsel for the petitioner does not oppose the prayer. Let this matter be listed after 2 weeks.
Let's.
What is to be done? Should we await further or you take precedent?
Because I have already taken steps.
When have you taken? You are on interim.
Yes, lordship, on 8/8/2023.
Take fresh steps. Heard Mr. L. R.
Yes,
Majumdar.
Ahmed.
Sorry. Heard Mr. A. Z. Ahmed, learned counsel for the petitioner. On perusal of the office note dated 3/1/2024, it appears that neither AD card nor unserved notice in respect of respondent number 2 has been received back by the registry. Learned counsel prays for allowing the learned counsel for the petitioner has prayed for allowing the petitioner to take fresh steps for issuance of notice on respondent number 2. The prayer is allowed. The petitioner shall take steps for issuance of notice on respondent number 2 through registered post with AD within 3 days from the date of this order. Returnable.
One more period, in this case, no lower court record has been called for in the meantime. Currently, see the last order 28/7/2023.
I have noticed Lordship, no record has been called for.
It has been stayed.
Yes, still but no record of the,
What is the matter?
Lordship is a quashing of the proceeding.
Stop. You, you have to take steps within 3 days.
Okay.
If you fail to take step,
No, Lordship, I will take it definitely. Earlier also I have taken steps.
Okay.
I have taken.
it appears from order sheets of this case that on 28/7/2023, further proceedings of sessions case number 8/2023 was stayed. However, it also appears that no trial court records were called for. Stop. As the perusal of the trial court record would be necessary for consideration of the instant criminal petition, hence call for the record of sessions case number 8/2023 from the Court of Learned Additional Session Judge Rangya. List after 2 weeks, list after 4 weeks.
Till an interim.
The interim order granted earlier shall continue till next day.
Aye.
I'll take a short break of 2 minutes.
Service has been completed. Lordship may kindly fix a short date for hearing.
Heard. Miss, what is your name?
M. Devi
M. Devi.
on behalf of K. Sinha.
On behalf of,
K. Sinha.
heard Miss M. Devi appearing on behalf of Mr. K. Sinha, learned counsel for the petitioner. Also heard Mr. M. Fukan, learned public prosecutor Assam. It appears from order dated 21/5/2024 passed by learned Lawajima Court that on the basis of the track consignment report of the postal department available in the court case record, it was observed that the notice issued to respondent number 2 was duly served. And the service has been completed in respect of respondent number 2. Stop. On perusal of the record, as well as in view of the observations made by Lawajima Court, the notice on respondent number 2 is deemed to be duly served. Let this case be listed for admission. Let this case be listed for hearing.
Yeah.
When do you want?
The immediate vacation.
Hearing after ensuing summer vacations.
Lordship may kindly fix.
No date. Registry will fix the date.
Okay, Lordship. Must obvious.
So for informant, notice was served. Also, in this case, Lordship, the copy of memo paper was not served upon us.
What for this interlocutory application?
The suspension of order, Lordship.
This is suspension of my lord.
You have objections against?
Yes,
You serve a copy of
the memo paper.
memo of appeal? Then
Yeah.
only your petition
Yes.
may be heard.
Actually, it was my lord, at the time of taking steps, it was given, oh, okay, my lord, I will serve them.
Heard Mr.
Jai Islam, my lord.
J. Islam, learned counsel for the applicant in interlocutory application. Applicant also heard Mr. M. Fukon, learned public prosecutor Assam, as well as Mr.
SK Chetri.
S.K. Chetri, appearing for the informant. Learned counsel for the informant has submitted that he has not been furnished with the memo of appeal, and therefore he is not in a position to object the interlocutory application, and prays for furnishing a memo of appeal to him. The the applicant is directed to furnish during the course of the day, today itself,
My lord.
directed to furnish a copy of memo of appeal to the informant during the course of the day. Stop. The informant may file a written objection if he so desires within a period of 1 week, 1 week from the date of this order. List this matter after 1 week.
Obliged. Obliged.
Case is listed very lately. Last order was 5/2/2022. Your lordship, in the meantime, they issued a warrant of arrest. Now, actually, the interim order, interim prior petitions will be considered after receiving the record from the Planet Court below. Already, LCR is in the record. Your lordship, what happened actually, it is not a criminal matter. It is a civil nature of
But
dispute.
it has come in orders column.
Orders. Your lordship,
Why it has come within in orders column?
actually, case is listed very lately case. Now we are facing the problem. Already issued a warrant of arrest. And actually, it is a civil nature of dispute.
Have you taken steps for issuance of?
Very timely. I am very timely step, but taking just a very timely. Record will speak the truth. Your lordship, what happened? Issued a warrant of arrest. Again, they filed a criminal civil commercial suit number 180/2023. Your lordship, it is criminal nature. There are so many reported decisions also. Your lordship. It actually what happened? Actually, it's a commercial matter. 1,48,47,67 amount total. They already paid the paid, and now balance amount is 37,098,445. But they are partly paying the amount. In spite of that, they filed a criminal case. It is a purely civil nature of dispute. Now it is not title suit, it is now money suit. Now the commercial suit already filed. The commercial suit number 180/2023 in the civil judge, senior civil judge, number 1 at Guwahati. And
Bailable warrant of arrest has been issued. Bailable warrant of arrest.
available one, they already issued. During the pendency of this, they are the knowledge. What is the knowledge already LCM? But my respectful service on interim of prayer may kindly be allowed
What is your interim prayer?
to stay the proceeding.
What is the ground?
Ground is, it is the purely civil nature of this. Payment already made, partly paying the rest amount.
What is the allegation in the complaint?
My lord,
What is the allegation in the complaint?
no, non-payment,
Non-payment of what?
or non-payment, that due amount. Actually, big amount was that 1,48,000 something. They already paid. Now balance amount is 37 lakhs 98,444 445.
Whether state is the party?
No, my lord. State party.
State party.
Is a complaint case. Who has filed this criminal petition? All the accused persons,
Yes.
all the accused persons.
Uh,
There are 6 accused persons.
Yes, ma'am.
All of them have filed this.
All of them are filed this.
Heard Mr. M. Talukdar, learned counsel for the petitioners. On perusal of the office note dated 6/6/2024, it appears that the notices issued to, though the notices have been issued to the sole respondent by registered post with AD, as well as through learned district magistrate Kamrup Metro on 29/4/2024. However, till now, neither the AD card nor the unserved notices have been received by this court, by the registry. It also appears that the scanned copy of the case record of CR case number 215/2023, which was called for, has already been received. Learned counsel for the petitioner has submitted that by order dated 5/2/2024, this court had directed that the prayer for interim relief to the petitioner would be considered only after receiving of the case record from the trial court. Learned counsel for the petitioner has also submitted that in the meanwhile, the trial court has issued bailable warrant of arrest against the petitioners. Hence, a prayer for staying the further proceeding of CR case number 215/2023 has been made by the learned counsel for the petitioners. Stop. It is further submitted by the learned counsel for the petitioners that though an outstanding due of
37 lakhs 98 for 445. Out of that, 1 crore 48, 47,
outstanding
6.
due of rupees why have you not paid this amount?
Now they are paying timely, time. Part payment is already made.
That out of the total outstanding amount of 1 crore 48 lakh 47,676, the petitioners have already made payment of rupees 37 lakhs 98,445.
Your lordship paid already 1 crore 10 lakhs 49,230.
How much?
One already paid 1 crore 10 lakhs 49,230. Already paid.
1 crore 10 lakhs.
1 crore 10 lakhs 49,230. Already paid.
The
Now-
petitioners have already paid an amount of rupees 1 crore 10 lakhs.
10 lakhs 49,230.
30 and an outstanding of
Balance is 37.
37 lakhs 98,445
44.
is there up to 31/3/2023, which the petitioner would be paying. It is also submitted by learned counsel for the petitioner that the dispute between the parties is purely of commercial nature, commercial within bracket civil nature, and the respondent has also filed a commercial suit before the court of
Civil Judge Senior Division 1 at Guwahati, case number commercial suite number 180 of the 2023.
commercial suit before the court of learned civil justice senior division number 1 Guwahati, which has been registered as commercial suit number
Commercial suite number 180 of the 2023.
180/2023. Stop. It appears on perusal of the scanned copy of the case record that in the complaint petition, the respondent has alleged that as the accused persons are reluctant to clear the balance account amount of rupees 47,98,441 along with the accrued interest. An accusation under section 420/406/120B/34 of the Indian Penal Code has been made against the present petitioners. From perusal of the complaint petition, prima facie, it appears that the dispute between the parties are predominantly civil in nature. Hence, till further orders, the further proceeding of CR case number 215/2023 is hereby stayed. The petitioners are directed to take fresh steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable on at the date given. Returnable on 17 July. List accordingly. It's okay.
May it please the Lordship, as per office note dated 8/5/24, Lordship, notice has been unserved, Lordship. We may take fresh steps, Lordship.
Miss
B. Goswami.
D.
B.
B. Goswami, learned counsel for the petitioner. As per office note dated 8/5/2024, it appears that notice issued to, how many respondents are there?
Respondent, Lordship, 1,
State of, the notice issued to
respondent number 2.
respondent number 1 has not yet been received back by the registry. Neither AD card has been received. Learned counsel for the petitioner has prayed for allowing the petitioner to take fresh steps for issuance of notice on respondent number 1. The prayer is allowed. The petitioner shall take fresh steps for issuance of notice on respondent number 1 by registered post with AD within 3 days from,
Interim order is there.
within 3 days from the date of this order, returnable after 4 weeks. The interim order shall continue till next day.
of let's.
May I please, Your Lordship? My lord, in this case, my lord, already, my lord, this matter admitted, elsewhere called notice issued state, my lord. But thereafter, we found them, my lord, the informant is also necessary party in this case, my lord. And we made this application for implement of the informant, my lord. My lordship, kindly have a look, the order passed by this honorable court on last occasion, that is on page 9, annexure 1.
Interlocutor application.
Yes, my lord. I have enclosed the last order. That is on 10/4/2024, my lord.
Yes.
The public prosecutor has represented, but the informant is also necessary in this matter, my lord. So therefore, we have made this.
Why informant is necessary?
Well, see, my lord, against conviction, we are before this court, the status party, my lord. Then he must get opportunity to also defend his case also. Insolvent. And 3 years conviction, my lord, under section 325. The public prosecutor representing, my lord, the informant, if this honorable court thinks fit, my lord, then he may be implicated.
Where is the observation?
My lord, the last order at page 9, annexure 1. In IA, my lord.
Where it is mentioned?
My lord.
Where? Read out.
My lord, it is not, my lord. This honorable court, notice issued, my lord. We realize, my lord, the informant. Without impleading, without what questions going on against conviction, we are before this court. If
informant is not aware what is going on, therefore we can fit it.
There is no observation by the
Then
court.
Lord, then Lordship may, if he is not necessary, then I may be,
Why you think that he is a necessary party?
we think that, my lord, against conviction, we have come in this case, the informant lost the affair against us, and in this affair, my lord, we have been convicted
Is
here.
it requirement of law? I'm putting query. If it is required,
State representing is not necessary, in fact, if.
whether informant is necessary.
My lord.
This is a revision against which order?
Again, on 6-24.
Conviction.
Yes, my lord, session Charles Kachar. Go to
Okay,
court.
implead him, there is no harm in impleading.
My lord.
Then
But
I will withdraw mine.
because you have filed this application under CPC
Yes, my lord,
and this is a criminal,
This is a criminal court.
so What?
I will.
on application of, on prayer of learned counsel for the petitioner, this interlocutory application is allowed to be withdrawn and same is dismissed as withdrawn.
And my lord, in this case, my lord, Elsia received, my lord. Lordship will fix it.
Main case too.
Elsia, right? It is 2024 matter, we are in. Elsia received.
You are on interim,
Yes, my lord, already till disposal stage by this court, my lord.
so your interest is in delaying the,
No, my lord, your lordship, since Elsia received, lordship, after vacation, in fact, fixed, my lord, no issue, my lord.
then we are fixing it after vacation.
Lord, yes.
Because this is a short-term sentence,
Yes,
3 years on.
yes, my lord, yes.
Heard Mr. P.K. Deka, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. Since the LCR, since the trial court record has been received by the registry, and since the sentence imposed on the petitioner is a short-term sentence of 3 years only, this revision petition is required to be heard at the earliest. Therefore, registry is directed to list this matter for hearing. after-
23rd or 25th
No
July.
fixed date, after ensuing
Vacation.
summer vacation. Registry will finalize the date.
Yes, my lord. Deeply obliged.
May I please your lordship? My lord, it is staying the proceeding, my lord. GR 8143.
May I please, your lordship? I want to have a question number 2. The senior counsel is not appeared today due to his illness.
My lord, I come to this court for to say the interest of justice, my lord. My lord, I filed a criminal, I filed a criminal petition. 110. 110.
No, the counsel for the respondent is not, he is ill today. So we are fixing a short date.
So that,
Obviously, my lord, this court passed order to the case diary of the scan copy. And also it is the cross case, my lord. Cross case, my lord. Main case is, my lord, the petitioner is on my left side, my lord. My lord, the petitioner, actually the brief matter is, my lord, the
No, no.
petitioner.
I'm not hearing it today.
Okay.
You are the
Obliged, my lord.
petitioner.
Actually,
You are petitioner in,
may I please?
yes.
Actually, my lordship, this case is a cross case.
The main case is in the police station, my lord. Actually, I had purchased the land from one broker in 2011.
No,
And,
today the
uh,
other side's
and
council is not ready.
This IA, my lordship, IA, that's why my lordship, in 2020, this, yes, there's a scan copy, the LCR scan copy was called for on third,
Why this IA has been filed?
third, 7 February 2020, my lordship. LCR scan copy. Annex number
No,
A,
what is your name?
page number 9, my lordship.
Matter
But here, my lordship, in 9/11/2022,
You are not listening to me. You have filed an IA, interlocutory application for
yes, my lordship.
stay of the proceeding.
I am telling-
Listen to me. Stay of the proceeding. Listen to me first. The other side is saying that their counsel is not ready and therefore they are praying for a short date. So first we have to consider that whether we have to proceed or to allow their prayer. If we allow their prayer, then we will be fixing it for on a next date, short next date. Then we will hear you. There is no.
Actually, IA is, my lord, here, the lower court has put it an order 9/11/2022 that here in order here written that again return the same to the court, to this court. Even this my honor, my lordship, their LCR is available in the High Court, my lordship. No any order after this order, my lordship, 7/20, after 7/20. Only correction for IA was IA order was available here, my lordship, 10/2/2021.
Okay.
That
Let-
I can't understand why here put that again return the same to this court,
Yes,
the LCR scan copy. And subsequently someone it is my lordship.
No, LCR is there. LCR is there. You may go through the LCR. Prepare yourself in a better way. Let the other side come. We'll be fixing it for.
May I pray my lordship to kindly please this admit this application, and my lordship kindly pray to call for complete original copy of LCR, my lordship,
Not necessary.
and kindly stay,
Heard.
kindly order to stay.
Because my lord, it is ostensibly that main case is pending, my lord.
To-
It is a close case to
Don't
hide the
speak, my
crime,
lordship.
to hide the crime from the, hide the crime.
heard. What is your name?
Here,
Name?
Arvind Das.
Heard Mr. A. Das, learned counsel for the petitioner. Also heard Mr.
S. Hussain on behalf of A.T. Sarkar.
S. Hussain, appearing on behalf of Mr. A.T. Sarkar, who submits that as the conducting counsel for the respondent, Mr. A.T. Sarkar is ill. An adjournment is prayed for today. Considering
Yes,
the
yes.
submissions made by learned counsel, a short
This is only for
adjournment is allowed. Let this matter be listed again on, when do you want? Suggest a date.
27?
Putul date. kya?
Within June. Within June.
21 June,
June,
Obliged.
short date, right,
21 June, matam next.
21 June. Offline ballot.
Cancellation of this.
Yes, Mr. Ahmed.
This revision is filed for cancellation of bail by the informant lordship. Here on last occasion, your lordship has directed to obtain a particular instruction from the court lordship. Lordship may kindly see on 30/8/2023. Instruction person, item 11.
Who has filed this criminal petition?
Informant has filed.
Who is for the informant?
Person was there. 11, Mr. M.H. Ahmed is there. He's not here.
Or M.H. Ahmed had.
Or your lordship may take up after some time.
Let
Let
the-
him appear. Let
Whether
him
he is
come.
available.
I was told that when this matter was initially called, one of his colleague was here probably. Or your lordship may fix any other date.
Heard Mr. A. Ahmed, learned counsel for
Private respondent.
private respondent. Also heard Mr. P. Sharma, learned additional public prosecutor. The counsel for the petitioner was not found on call. Therefore, let's this matter again give a fixed date. On 19/6.
Obliged.
Yes.
Let me, your lordship. Your lordship, this revision is filed. That impugn order, your lordship will find page 24. First order, lordship may see page 21. Page 21.
Yes.
Here also some cows were recovered from a grazing field and thereafter FIR was lodged against some other accused persons. And petitioners, 4 numbers of cows were there in the grazing field. So police seized all the cows. Thereafter he filed Jimma application. Even in page 21, last line lordship will find cows are no longer required for purpose of investigation. And then lordship, page 23 lordship may kindly see. Page 23. Because section 11(5) was applied and the trial court rejected my application, lordship.
Read this para, however.
However, as the offence is registered under section 13 of Assam Cattle Preservation Act 2021, before deciding, Jimma court must have to consider the provision under section 11(5) of the Act, which provides that the magistrate may release other articles and conveyance except the cattle on Jimma. Thus, during inquiry, inquiry or trial, giving the cattle to Jimma to anyone, including the owner, is strictly prohibited. So
What
that
is 11(5)? What it says?
11(5), just I am reading. Power to enter, inspect.
Who is
search,
on the other side? On the
State.
state? Okay.
11(5). On receipt of the report, the judicial magistrate first class may, on his being satisfied that there
What
is
report?
enough.
It speaks about a report. What
Uh,
report?
That report that after seizure, lordship, the police have to report to the nearest magistrate immediately. Subclause 4, lordship, that I am reading. After the seizure under section 14 of section 7 and subsection 3 of section 11, such police officer shall report such seizure without unreasonable delay before the judicial magistrate first class.
Report of seizure.
Yes. On receipt of the report, the judicial magistrate first class may, on his being satisfied that there is enough material to presume that a prima facie offense under this act has been committed or intended to be committed, release the seized materials, including vehicle conveyance, except cattle, on furnishing a bank guarantee equal to the value of the material or vehicle conveyance, except to the satisfaction of the court, pending disposal of the criminal proceedings instituted in respect of the alleged offense.
Okay.
So now our High Court in coordinate, then so lordship will find. I have on the other day, it is probably in the file, lordship. Criminal revision petition 321. Al Farouk Farazi. That issue was already decided and it is said it is may used as it is a lordship discretion upon the court.
Read that provision.
Paragraph lordship 8 and 11. 8 I am reading lordship, 8 and 9. It is to be noted here that the petitioner is the owner of the seized cattle and this fact is not disputed by the respondent side. Despite the learned court below has dismissed the petition on the ground that section 11(5) of Assam Cattle Prevention Act provides that the cattle cannot be released in Jimma of the petitioner. A perusal of the aforesaid section reveals that on receipt of the report, the judicial magistrate first class may, on his being satisfied that there is enough material to presume that a prima facie offense under this act has been committed, release the seized materials, including vehicle conveyance, except cattle, on furnishing a bank guarantee equal to the value of material or vehicle conveyance to the satisfaction of the court, pending disposal of the criminal proceedings instituted in respect of the alleged offense. Then paragraph 11, lordship may kindly see. A cursory perusal.
Yes.
A cursory perusal of the aforesaid section reveals that the learned court below has failed to record its satisfaction that there is enough material to presume that a prima facie offense under the Assam Cattle Preservation Act 2021 has been committed or intended to be committed. The case was registered under section 397, 411, 429, 34 of Indian Penal Code, read with section 13(1) of the Cattle Preservation Act and 11(1)(d) of the Prevention of Cruelty to Animal Act. To attract section 13(1) of the Assam Cattle Preservation Act, one has to contravene the provision of section 4, 5, 6, 7, and 8. A bare perusal of the impugn order reveals that no such satisfaction is recorded by the learned court below. Without recording such satisfaction, it cannot be said that the impugn order so passed by the learned court below withstand the test of legality, propriety, and correctness. This court in criminal revision number so by judgment has directed to release seized cattle in the interim custody of the petitioner pending trial, imposing some conditions on the basis of the judgment of honorable court in manager so. And I find that the present case is squarely covered by the aforesaid judgment and order, and as such, the petitioner is entitled to similar relief granted to the petitioner of the aforesaid case. Here also the petitioner.
What the Supreme Court says, this Pinjira Paul. Devda.
Pinjira Paul that in next judgment, your lordship will find that criminal revision petition 429 of 22, Sirajul Islam lordship.
Where is this?
That is quoted in paragraph 11 in that. I have given one copy. Sirajul Islam.
Okay.
That one of the criminal revision petition 429/22.
In this case, which you are relying um, of the coordinate bench,
Lordship,
Al Farouk, Farzi,
Lordship,
Farazi,
Lordship.
there the relief was granted because the observation that prima facie offense has been committed was
Is
not there,
Not there,
was not there.
not there. Here also, I am not an accused.
Okay.
I am not an.
And the cattle ownership has been disputed.
Ownership, Lordship, we have submitted those documents before the court below.
But court below has only because of the embargo of section 11(5).
Lordship. And also one thing, just page before, Lordship, that page 27, Lordship, may I kindly see. Page 27.
Yes.
Last 4 line, Lordship, may I kindly see. As such, absence of any valid permit as described in the act, and there being no material showing any valid permit being produced by the accused persons, justifying the possession of the said cattle cow being seized from their possession. My submission is that, Lordship, those cattle were not transported. They were, my cattle were in the grazing field. Due to flood, it was there. They seized it from in that broad daylight. It is not a case that at the night these were transported or from the vehicle. It is not that case. It was seized from a grazing field that your Lordship will find page 19. It is their document, page 19.
What is this page 19?
Page 19. This is the second second photograph your Lordship will see. That from grazing field it was seized.
Now, what is there in the seizure list?
Seizure list,
From where it has been?
seizure page 15, Lordship will find page 15.
But it's
Page 15, vernacular, Lordship will find page 17.
from where the cows were seized.
Place of seizure, Sorupur. It is written. From Lordship, it is there. Just I am placing that part. Hereby seized the below descriptive cow cattle from the possession of Abdul Motin, so and so, Abdul Haq, with reference to so and so. So these 13 numbers were recovered from Abdul Motin. And now relating to my cows, Lordship will find page 18. SI Pranab Mili of so and so do hereby seize the below descriptive cows on being laid and shown by Abdul Motin in connection so and so in presence of so and so. Place of seizure, Lordship may kindly see Sorapur nearby jungle. And time, Lordship may kindly see 11:40 p.m. later. Or night. 11:40 night.
11:40
Night time. Sorry, night time. Because of flood, it was there. I have stated in my petition also that paragraph I am placing. Paragraph 4, Lordship may kindly see, paragraph 4, page 3. Because of flood, it was kept there.
Now, what is your interpretation? What is your? Now, where is the impugn order?
Impugn order, Lordship, page 24 and 21. 21 passed by the court, judicial magistrate, and then page 24 is the appeal. In the appeal, it was
Judicial magistrate
Lordship. Yes.
rejection ground was only the
11:5.
11(5).
11:5.
Embargo of 11(5).
11.
After framing primary satisfaction.
No, what's that we will discuss. And the in appeal, this
Yeah.
appeal is under what provision?
Section 12.
In appeal, what was the ground?
Ground
Of
that
upholding.
the accused persons failed to produce any valid permit and 11.5. And valid permit, I have already submitted that.
No, the appellate court did not discuss the 11.5.
11.5 discussed, Lordship. It is discussed. Paragraph page starts from page 27.
What this Pinjara poll judgment says.
That is mentioned, Lordship, in the judgment. In paragraph 11 of.
Now what is your submission? 11.5 is there which bars
Lordship.
a magistrate to give custody of a cattle
Lordship.
if prima facie there is a opinion that some materials are there for committing offense under that act.
Lordship.
And on that ground only, the magistrate rejected the Jimma prayer.
Lordship.
The Sessions Court upheld the rejection order and also added some more grounds that you failed to produce any valid documents.
Valid permit. I have
Valid-
placed the documents, but
valid-
valid permit.
Valid permit.
Permit. Because it my whole case is that I was not transporting. It was.
Okay, so question of permit is
Not required.
now, what is your submission regarding 11.5?
11.5 Lordship, regarding 11.5 Lordship, that I am not an accused in the present case. I am being owner Lordship that first 13 cows were recovered from the FIR name accused number 1 Abdul Motin.
And thereafter he showed some.
Thereafter he said shows that 4 cows are there. Then my 4
He
cows.
showed your cows also.
More, oh yes.
Okay.
And therefore, in the present case, I am not an accused. Police also Lordship did not find any material against me that I was involved in the alleged offense.
Otherwise, suppose an accusation has been made, if it is made against you,
Lordship.
then under
Then
11.5
that
it cannot.
satisfaction can be recorded. But in the present case, I am not an accused. For that satisfaction is not
Yes,
required.
Mr. Das. Anything else?
At that much.
Submit present.
That's it. Bishop.
This is. Now, Lord, those cows in question was recovered on being led
This
by the
prayer is as regards only 4 cows.
4 cows.
13 plus 4. Earlier 13 were recovered from the position of co-accused.
So accused, Abdul Motin.
And co-accused showed 4 cows later on
Later.
in the grazing field,
Yes,
which you are claiming that they are your cows.
my cow.
And in support of that claim, you have also produced some documents.
Documents.
Okay, this is the fact. Yes.
Now, question arises that those cows were seized on being led by the other accused person from whose other cattle were seized. Now, I do not know without going through the case that whether the said accused person claimed that those 4 cows were also purchased from him or not. All these things are there. And so far, 11.5 is concerned, that is a statutory bar. The whatever the case may be, the cows were seized in connection with the offense allegedly committed under the Prevention of this Cattle Transportation Prohibition Act. So, statutory bar, I think an on appeal, the order of the learned magistrate has been upheld by the appellate court. Being concurrent finding, I do not find any reason for interfering with the impugned orders.
Okay, once more. How the session judge has dealt with 11.5?
Yes.
Read that
It's
paragraph.
27,
Paragraph 9, Lordship, may I page 29.
27 of
Discussion starts from page 27 and findings, your lordship, will be paragraph 9, page 29.
It is pertinent to mention that the presumption of there being prima facie material that offense under the act has been committed being the requisite of section 11(5) of the act. As such, the bar under the said section gets attracted applicable sooner. The concerned magistrate draws satisfaction towards the said presumption. In the instant case, the relevant materials, including the FIR and the seizure list, shows that the case under section 13 of the act is registered on the basis of the allegation of commission of offense by the accused persons under under section 7 of the act, as per which the cows being seized were transported illegally without any valid permit. As such, absence of any valid permit as described in the act, or there being no material showing any valid permit being produced by the accused persons justifying the possession of the said cattle cows being seized from their possession as prima facie apparent from the seizure list on the record is the satisfaction of there being relevant materials for presumption of commission of the offense. In the instant case shows that the perusal of relevant record or materials in the instant case shows that the appellant admittedly has not produced any valid permit as prescribed in the act, but some documents regarding his alleged ownership of the said cattle, which in the light of the aforesaid provision as discussed above is not the relevant document required for consideration, rather the claim of the appellant alleging himself to be the owner of the seized cow impliedly shows or in other words suggests establishment of the fact of the accused persons being in illegal possession of the seized cattle, or the same being found to be transported without valid permit, thereby admittedly there being prima facie material that offense under the act has been
What
committed.
permit?
My lord,
What permit?
Permit is required if it is transported from
Permit for
one
what?
district to another district.
for
For
transit
transportation.
permit.
Transportation.
But these cows were seized near jungle.
That is why it is stated, found to be transported. That is why it is recorded, found to be transported.
Where is from what, on what basis that observation is made?
That is on the
Yes,
basis of, certainly on the basis of this statement of Abdul Motin, perhaps, my lord, that will be revealed in the case there only. That
Copy
can
of-
be ascertained on what basis the learned courts below came to a conclusion that these 4 cattle were also supposed to be transported.
Yes.
That can be ascertained only from the case there, my lord. The case there is not before your lordship.
Where is that observation found to be transported?
My lord, page 28, page 28 above,
Last line from.
fifth line. Fifth
From
line.
bottom, fifth line.
Accused persons being from 6th line, your lordship, may I kindly see. Accused persons being in illegal possession of the seized cattle or the same being found to be transported without valid permit.
No, in this revision, our jurisdiction is limited. We cannot go through case diary. We will only see whether
Whether,
the
yes, there
judgment
is
is illegality.
material irregularity or my lord.
If on the basis of materials which is available on record. Okay. I'll reserve it. Heard, Mr.
And only one thing, Lordship, and if I may, page 21, your Lordship will find that the documents regarding his ownership was submitted. And regarding that, there is no finding in both the judgments, both the orders. Page 21, and in fact, Lordship may kindly see page 20 first. Initially, when I filed GMA application, I annexed all the documents. But I hope initially said, Lordship can see page 20.
What documents you have furnished?
That documents certified copy I have not received, Lordship, but it is
No,
mentioned
just
that.
make submission.
Lordship.
What kind of documents are required for having a cow?
He must have purchased from somebody.
Okay. But suppose purchase is from local villagers, then what document would be?
Nowadays, after Cattle Preservation Act, it is required.
That is
the requirement.
receipt is required.
What is required? That is
That
my
if
question.
somebody is having cows prior to this amendment, Lordship, then also he have to inform the authorities.
Okay.
That-
Then any transaction, any sale of cows have to be registered.
Yes, that
Some
is,
registration is there.
Lordship, registered my animal market also. From animal market, that can be done.
Okay. What will happen if
Otherwise, nowadays, insurance is also there. Insurance provisions is also there.
no, suppose some
insurance.
villager want to sell his cow to some another villager? How he will sell? What is the procedure?
In the act, it is not there. If only it is said, if it is transported to out of state.
No, just I want to know whether he has to get his cow registered and then only he can sell it, or he can sell it to another co-villager.
Because my understanding to the act is that it is mainly for slaughtering, Lordship. For cruelty, Lord, only that part. For agricultural purpose, it probably do not cover, Lordship. Subject to correction, what my learned friend say, because act of the object of the act itself says that part.
Slaughtering is
Mainly
selling of beef. Beef is
slaughtering.
prohibited.
Okay. Mr. A. Ahmed, learned counsel for the petitioner. Also had Mr. D. Das, learned additional public prosecutor. Hearing concluded, judgment reserved.
Obliged.
My lord, in this case, my lord, I have prepared a written argument, my lord. You see?
Till now, we have heard the interlocutory application.
Yes, ma'am.
But as the matter has come
Yes,
in hearing column, we can dispose of the matter
yes, my lord. That is why I have prepared the written argument.
instead
also.
of,
What I have argued, my lord, last 3 days, my lord.
okay, very good.
No. Very good. Lordship, kindly come to the my lord. Today, my lord, that is irrelevant now. 2 years, 8 months, 2 weeks, 3 days, his custody, my lord. And conviction under the 21C, my lord. And 13 bottle of codeine escape cough syrup contained 1300 ml cough syrup in total, comprising 234 gram, my lord, considered to 1.3 kg has been recovered, my lord. Only 13 bottle cough syrup has been recovered, my lord. My lord, the spirit of Hirasi, following the spirit of Hirasi, that has been mentioned, my lord. I want to show one thing, my lord. Evidence, I already, my lord, read, my lord. One important evidence I have found, my lord. Whole case has been demolished by this evidence, my lord. Lordship, kindly go to the evidence of PW6 IO.
Just a minute.
PW6. His name is Muktab Ali Bora.
Yes.
If your lordship go to the my lord, first, second, third, fourth, my lord, fifth paragraph. Sample were done in presence of medicine. I was present in the court. I obtained 52A about correctness inventory and another certificate showing correctness photograph of the seized and group. Exhibit 12 and 13 are the two certificates issued by judicial on the pair made by 52A and DPSA. Third certificate is not available, my lord. As I have already argued, my lord, that certificate in respect of list of sample and why is required in this case, I will show you.
Just a minute, where is exhibit 12? 12
Well,
and 13?
second last paragraph. Last but second paragraph. ma'am.
Okay, two certificates.
Two certificate issued by deed and judicial magistrate first language 52A of NDPS Act.
According to you, the certifying the samples,
Sample were not
list
available.
of samples drawn
Not available.
is also necessary.
Yes, my lord. It is important, my lord, because your lordship kindly turn up the page, my lord. Turn the page. Next line. Next paragraph. After drawing sample, same were sent to FSL to SP office, Morigao. I have collected FSL report which gave test of heroin. How can my lord putting this cuff, escape cough syrup, my lord, found as a heroin, my lord?
Oh,
And the entire case has been demolished. Let's kindly go to this line, my lord. That is why, my lord, that certificate under 52A of NDPS Act is necessary, my lord. Because, my lord, what happened in the instant case, my lord?
but what FSL report says?
FSL report has been said, my lord, it is a codeine phosphate. I have gone through it, my lord. But, well, let's kindly go to the evidence, my lord. Under 172, my lord, of my lord, CRPC, my lord, we can only take the legal evidence, my lord. Other evidence we cannot take, my lord. This is the legal evidence, my lord. And evidence supported to the accused person, my lord.
Yes.
And next important thing is that, my lord, when it was sent to the, my lord, FSL, my lord, your lordship kindly come to the that forwarding letter, my lord. Yes, sir. Yes, my lord. Lordship kindly exhibit your number like exhibit P8. Yes, my lord.
Exhibit P8 on 9.
Yes, my lord. Yes, my lord. P89. To the Director of Chemical Examiner to the Government, Director of Forensic Kahilipara, Guwahati. Please find here a report and close report number so and so with Moirabari PS case number so and so 21C NDPX. Have you also got it, my lord?
Yes.
Right, memo number so and so dated 13/9. Special messenger, please acknowledge receiver. Exhibit return for all future correspondence summon report. Number may please be quoted Sri Sandan Das, scientific officer, Drug so and so Kahilipara for evidence necessary. Next page, you'll also come. You'll also come to the next page, my lord.
Yes.
That exhibit P9 TSL. PW5, P9 by PW5. The officer in charge, Moirabari Police Station, your memo number so and so 13 advising examination. One parcel messenger which received office 110 mode in which parcel found to be received on the decision. The parcels contained one exhibit enclosed seal envelope. The facsimile of seal was found to superintendent, so copy of label attached to the article, pursuant to article 11, copy for one seal envelope marked as exhibit A having seal plastic bottle, one bottle, my lord, with 100 ml liquid substance, branded escape, marked here as DN 1991-2020. Batch number is also not mentioned, my lord. If they said, my lord, from the one bottle, my lord, they have taken representative sample of one bottle, my lord, although that is not permissible, then that is different aspect. When batch number was not mentioned, my lord, other bottle may be other medicine also, my lord, because their case is that, my lord, there are some other medicine also, my lord, recovered in that particular expired medicine, my lord. And that for that, my lord, they were separated register, no? Separated register other cases, my lord. How can they say, my lord? Because it is proved beyond all reasonable doubt, my lord. In the annual exhibit, that D won a positive test for codeine, amount of phosphate 182 mg. The report is contrary to the evidence given by the, my lord, PW 6, my lord. A humble submission before your lordship is that first it is a mandatory.
The batch number is not mentioned
Yes, my
in
lord.
the sample.
Yes, my lord.
How it affects the results?
Yes, my lord. I am coming, my lord. Why legislature has thought, my lord, list of sample is required, my lord. If they mention the best number, my lord, then they may, their case, they may argue. On behalf of me, I argued before your lordship is that because best number is the same, my lord, so other matter is same. But best number was not mentioned in the report, my lord. How can they say it, my lord, that this bottle
The
is
other bottles are from same batch or not?
same batch or not, my lord? That is, and it is also mandatory, my lord, list of sample. That is why legislature think, my lord, that this 52A4 has been incorporated in the NDPS Act, my lord. Wait for me while I analyze. Yes, my lord. Second important thing is that, my lord.
No, please read 52A4
Yes, ma'am.
once again.
52A, my lord. Your lordship come to the, my lord, directly make an application to the minister for the purpose of certifying the correctness of inventories. 52A to A.
2A,
Yes, my lord.
2C,
2C, my lord. My case is C.
2C.
Allowing the representative sample of the
It's not
drugs
52A4.
or substance in presence of such magistrate and certifying the correctness any list of samples so drawn. Sorry, my lord. I have, my lord, wrongly mentioned 52A to C.
Now what it means, certifying the correctness of any list of samples. So
Yes, my lord. The sample.
why this any word is there? Suppose if no list of samples is drawn,
Then there
can there be a
cases.
circumstance where no list of samples? may
Yes,
be-
ma'am, there is a case, my lord. If there is no list of sample, my lord, their case has gone, my lord. That is why this thing has been there. Certifying the
You
correctness.
have any supporting case?
Yes, my lord. Mohanlal and subsequently followed Bothilal and Yusuf case, my lord. Same case, my lord.
What it says?
Yes, my lord. A photo to the remote.
In your argument, written argument, you have mentioned.
Yes.
Yeah, I have mentioned all these things, my lord.
Para 15, 16.
Lordship, kindly come to the para 15-16 Mohanlal case, my lord. Mohanlal to DS,
Yes, flag 1.
flag 1, my lord.
Mohanlal, para 15.
Yes, my lord. It is manifest, have you also got it? Manifest from the 52A to C that upon seizure of contaminant. One,
Just a minute.
এখানে পেজ নাম্বার দিয়ে বলেছিল পেজ নাম্বার দিলে পতা করে দিলে থাকে
Page 4.
নয় Internal page 408, my lord. The judgment. No, I could take it.
Yes, yes.
It is manifest from section 52A to say, supra, that upon seizure of the contraband, the same is informed either to the officer in charge to the nearest police station or to the officer employed on the section 50 who shall prepare an inventory stipulated in the said provision, make an application magistrate for the purpose of certifying the correctness of inventory, certifying photograph of the drugs, so the drugs or substance taken before the magistrate to draw represent sample in presence of the magistrate and certifying the correction of the list of samples so drawn.
So C is conjunctive. It is
Yes, my lord, that is mandatory, my lord. Then, my lord, logic in paragraph 17. The question of drawing sample at the time of seizure, which more often not take place, substance of magistrate does not above that they arise. This was specially according to 52A(4) of the Act, sample drawn certified by the magistrate in compliance with the subsection 52 2, 3, 60 consider primary evidence for the purpose of the suffice it to say there is no provision in the Act that mandate taking sample at the time of seizure. This is perhaps why none of the state claim taking sample of the seizure. Accordingly, my lord, this is mandatory. It has been said. My 31.1, my lord. Page 416. To sum up, we direct that no sooner seizure narcotics drug and narcotically controlled substance conveyance affected, the same shall be forwarded to the officer in charge of the nearest police station. To the officer under section 653 of the Act, the officer employer shall then approach the magistrate and application under section 52(8)(2) Act, which shall be allowed by magistrate as soon as required. Subsection 3 of section 52A, as discussed in body of the judgment, heading section 50 discussed by the body of the judgment, heading seizure and sampling. The sampling shall be done under the supervision of magistrate, discussed 15 to 19 under. And most important thing is that in this case, my lord, seizure witness subject to denied. Seizure witness has never said PW 1 if your lordship go that the psychotropic substance has been recovered, my lord. He has never said, my lord.
now your submission is under 52A to C.
Yes, my lord.
A list of sample
Yes, my lord.
is to be prepared and which has to be certified by the magistrate.
Magistrate, my lord.
Suppose it is, if it is not done,
Then my whole case has been vitiated, my lord. And why the intention and purpose of the legislature I have submitting in this case that batch number has not been mentioned when it was sent to the FSL. An important thing is that, my lord, that sample were not produced before the court, my lord. And it has not any explanation that whether it was destroyed, dismantled or other, my lord. They are silent. I have, to that effect, I have submitted some judgment also, my lord. In my written argument, I have said, my lord, that the sample which has been taken, which has been given for sent to the FSL, my lord. That was, my lord, after FSL, it was came back, my lord. Whether it was destroyed and why it was not produced. If it was destroyed, my lord, then they should produce the certificate. That sample has been destroyed. But that certificate is also not available. And sample is also not available, my lord. To that effect, Noor case is available, my lord. They have to produce, my lord. Either certificate or, my lord, sample.
remaining sample.
Remaining
Because some
sample. my lord.
sample may
Yes,
be
my lord.
consumed.
Actually, whole procedure has been wrong. There are two samples should be, one original, one duplicate. Duplicate should be sent to the FSL, my lord. And original should be kept in the, my lord, custody of the, my lord. That's the DS and Nuragato. It am now.
Yes.
One husband, my lord. To that effect, my lord. 2008 16 SSC 417 Noor Aga versus State of Punjab and para 96, my lord. Lordship, it is a very small, as I read my lord slowly, that thereafter I shall give book to your lordship. Last but not the least, physical,
Varga, you have given that judgment.
in that is not available, my lord. Just half an hour before I got this judgment, that is why. Last but
What is the citation?
2000,
816 SCC
Yes, my lord.
417.
yes, my lord. 2008, /16 SSC 417. Para 96, my lord. Last but not the least of physical evidence related to three sample taken from the bulk amount of heroin was also not produced. Even it is except the sake of argument bulk quantity was destroyed, the sample were essential to be produced and proved as primary evidence for the purpose of establishing the fact of recovery of heroin as envisaged under section 52A of the Act. Lots of I'm relying on the
So sample was required to be produced.
yes, my lord. 50 to 96. আগে একটু পড়ি লগ লাস্ট দেখাম জপিয়ে থাকলে নহব একটা
Okay. Yes.
Yeah, then you're also following this judgment, my lord. I have annexed here, my lord. Another judgment, my lord. Bijoy Jain versus State of MP, my lord. I have given, my lord, in that, my lord.
Yes.
To 2013, 14 SSC 527.
What it says.
That compilation, my lord. Para to pin, no?
Paragraph.
Sorry, no.
10.
Yes, my lord. Para 10. Have a lot of got it?
Yes.
On the other hand, on a reading of this court judgment, the tender case, we find that the court has taken a view that trial for offence under NDPS Act, it is necessary for the protection to establish a cogent evidence that alleged quantities of the contraband goods were seized from the possession of the accused, and base evidence to produce this fact to produce during the trial. The seized material as material object where the contraband material alleged to have been seized are not produced, and there is no explanation for the failure of produce contraband material by the prosecution. Mere oral evidence that material were seized from the accused would not be sufficient to make an offense under NDPS Act, particularly when punch witness have punch hostile. Here in the instant case, if you also go to the evidence of PW12, they are not hostile, but they are not support the, my lord, that contraband has been seized. I will read, my lord, later on, my lord.
No, how Vijay Jain help you?
My lord,
Because in this case also PW1 and PW2 have not supported
yes, my lord.
prosecution's case.
Prosecution, he has not supported prosecution case. He said something has been recovered. He never said that that contraband has been recovered from the house of the exact evidence I shall leave, my lord.
PW1 cross.
Hmm?
PW1 cross.
Yes, madam. Cross by it. I cannot say with certainty that experienced medicine were cough syrup bottles. He said PW1. I will come later on, my lord. If I jump here, there, my lord, after that, my lord.
These articles were not produced in our time.
There in the seized article were not. It has not supported that cough syrup has been recovered. And my lord, sample were not produced before the court, my lord. So it was helped me, my lord. Then you will also come to next judgment, my lord. I can look.
Yes.
Vijay Pandey, my lord, next husband, paragraph 5, 6 and 8. I am reading my, slowly reading my lord. Paragraph 5.
Yes.
We have considered respective submission. The seizure was at 6:40 AM at the doorstep of the appellant. Here, as per instant case, my lord, I am one point I have to mention, my lord. As per seizure list, it was PM,
3:45 PM.
3:45 PM. But the whole prosecution case is that in the morning, my lord, in the intervening night, the goods were seized, my lord. Whole prosecution case. There is a, my lord, that the major discrepancy I found. We find it difficult to believe that in a rural residence located, police were unable to find a single independent witness. That is not important. Not name of any person mentioned who may be declined to be witness. Like despite noticing absence of recovery of PPR at the time of seizure, section 50, and they opined that deposition of police witness to that effect sufficient. Though the laboratory report was obtained, have you also got it? That is important.
Which para?
Paragraph 5, last but 3 line, my lord.
Yes. Yes.
Though the laboratory report was obtained, but the identity of the sample stated has been seized from the appellant was not conclusively established by the prosecution. Next, the accused has raised objection regarding the sample produced in court not having been established as a seized from him. The trial opined that Malkhanas in the state of Uttar Pradesh, where miserable conditions stands objectionable thing, some in the eyes, the plastic packet produced was very low quantity. In use in writing, the name accused the same was not disparable, and many have got erased with passage time. Not that the seized the allegation against the appellant have been produced by the failure of conclusion identify the sample produced having been seized from the appellant was inconsequential. Same like me. Unfortunately, High Court did not deal with this aspect of the matter at all. Here in the instant case, the Malkhana register was not produced before the court, my lord. They have to produce because on night they have seized and it was there as their case, it was put before the Malkhana, my lord. And what is this?
28 of the into Paris, 29 for
On 20 whole day in the Malkhana as per prosecution case. On 29 it was produced before the magistrate, my lord. They have to produce the Malkhana register, my lord. And particularly when, my lord, police officer says the report is heroin, my lord. A Malkhana register not produced. Sample is not available, my lord. Nothing is available. It was not produced before the court. And there is no certificate that sample has been demolished. Then, my lord, prosecution case has been fatal. The para-8, my lord. The failure in the present case to relate to seized sample that seized from the appellant make case no different from failure to produce seized sample itself. In the circumstance, mere production of laboratory report that sample tested narcotic cannot be conclusive proof by itself.
So the FSL report is itself not sufficient.
Yes, my lord.
Into judgment rate.
In my lord, my written argument, my lord, I have stated in para 11, my lord. If your lordship go to my written argument, my lord. Yes, my lord. Secondly, I am reading slowly, my lord. Secondly, although the seized article were purportedly kept in Malkhana prior to being produced before the learned judicial magistrate on 29/9/2021, no Malkhana register was exhibited and proven before the trial to prove the fact. Further, the prosecution omitted to adduce any evidence regarding whereabout the sample in question before it was transmitted to the FSL office. No witness also examined to prove manner of commutation of the said sample. That line important. The prosecution did not prove a manner of commutation of the said sample. Then prosecution did not prove single document regarding safe keeping of the alleged contraband from the time till the same is reached to the FSL. No document has produced it.
One thing. Where batch number is not mentioned in the FSL report.
In FSL report, batch number was not that. So
or in the forwarding,
In the FSL report, batch number was not mentioned, my lord.
not mentioned.
It is an admitted position that it was not mentioned, my lord. Because I have read that report, my lord. That's now, my lord. Forwarding report as well. And if PW, for your lords, look to the cross examination of PW5, he has categorically stated, my lord. May I read, my lord?
Yes,
That part, my lord.
PW5
Yes,
regarding
madam.
batch number.
Not mentioned, my lord. The sample have been received by our office. Thereafter, the director handed over same to me. I have not enclosed the authority letter given to me for examining my report. In my report, I have not mentioned the detailed finding of the report. I have only given the conclusion result. In my report, I have not mentioned the batch number of the sample received. Last but 3 line of the cross examination of defense. I have not mentioned the batch number sample, if any.
Page 3 of the LCA, 29,920.
How sample was identified?
My lord, they have given some, my lord, specimen mark. On the basis of that, sample has been, my lord, mentioned. My lord, my humble submission before your lordship is that, my lord, why I am arguing that for batch number, my lord, because there are 13 bottle has been recovered.
No, that I have
One
understood.
bottle has been
Other
theft.
bottles may be of some other medicine.
Other material, my lord, particularly when batch number not mentioned in the either inventory, nothing, my lord, nothing has been mentioned, my lord. Even mentioned in the inventory also, my lord. Then also, my lord, inventory mentioned, huh?
MR number batch number. Can you tell?
Yes, my lord. When inventory where batch number is there, but when it was sent to the FSL, there must be a batch number, my lord. Otherwise, how can I say? That is why I am submitting.
You want to say that to ensure
Yes, my lord.
that the sample is of that contraband which was seized.
Yes, my lord.
The sample of the inventory,
Yes,
the
my lord.
batch number of the inventory and batch number of the sample should match.
And my lord, my humble submission is not that, my lord. My humble submission before your lordship is that when a sample has been sent to the FSL, my lord, they should mention the batch number, because it is a case of the petitioner, my lord, prosecution, that they have sent one bottle, my lord. They have not sent, my lord, from each bottle. Whether there is a notification, our judgment also, my lord, that you have to take sample from each bottle, my lord. That
So
is not,
sampling was not done according to the
yes, my lord.
that 89 notification.
Yes, my lord, that notification. I have that judgment also, my lord. And when that is not available, I am further argued before your lordship is that FSL also, report of FSL, there is no batch number has been mentioned. Most important thing is that, my lord, the letter by which the sample has been sent to the FSL, that was not exhibited by them. My lord, in inventory, my lord, batch number was not mentioned, my lord,
Batch number was not mentioned.
in the inventory, my lord. না করা mention, আর একটা সাইড নোট আছে। এখন ডকুমেন্টস না। Right, correct. Report finish.
Whether the photographs were exhibited.
A photograph were exhibited.
Exhibited.
Photograph exhibited, but in inventory batch number is also not available.
That is exhibit P6.
Photograph exhibit.
P6.
P6.
Yes, my lord. Photograph exhibit.
Then from photograph we can see.
Yes. Then your lordship kindly look to the photograph also, my lord. Important thing.
P4 also there.
Yes, my lord. Your lordship kindly look to the, my lord, photograph. How can, my lord, batch number can be, my lord, on the photograph? This is the photograph I have got.
I argue, my lord, why 52A23 is important, my lord. But as per apex court judgment, my lord, 52A23 is mandatory, my lord. I argue furthermore, my lord.
Where it is stated. it is
Yes, my lord.
mandatory.
You will also kindly come to the judgment, Yusuf, my lord. And section has already said, my lord. Flag 4. তাতে দিয়া আছে ন ঠিক আছে Para 12 to 16.
No, that list of sample, certification of list of sample is mandatory.
Yes, mandatory.
Where it is.
Yes, 15 and 16. In Mohanlal case, the apex court, while dealing with the section 52A of ND clearly laid down, it is manifest from the said provision that upon seizure of contraband, it has to be forwarded either to the officer in charge to the nearest police station or to the officer empowered section 50T, who is obliged to prepare an inventory of the seized contraband and then make an application the magistrate for the purpose of getting correctness of certified. It has been further laid down that sample done in the presence of magistrate and the list thereof being certified alone would constitute primary evidence for the purpose of trial. Have a look at it. List alone, the word has been used, would be certified list alone. Then paragraph 6, in the absence of material record established that sample of seized contaminated done in presence of magistrate, inventory seized contaminated duly certified, it is apparent that the seized contaminated sample of done would not be valid primary evidence. One, there is no primary evidence, the trial will stand appreciated. I am relying other judgment, but this judgment is appropriate answer in respect of that matter. In respect of other judgment, I have annexed matter. And Mohanlal has been relied on this judgment also, my lord. Bothilal and Simaranjan Singh, my lord. And in both this judgment has said, my lord, if Mohanlal was
Now
not.
read 16 again.
Yes, my lord. In absence of material on record established that sample of seized contraband drawn in presence of the magistrate, that inventory of seized contraband was duly certified by me, it is apparent that the said seized contraband sample drawn thereof would not be valid piece of evidence of that. One, there is no prima facie evidence available, try as a whole stand appreciated. 15, 16, you will see it conveniently, my lord. 12, you will see from 12, my lord. 12, 13, 14, 15, 16, my lord.
So your submission in this case, as there is no certificate.
Yes, my lord.
Of list of samples.
Yes, my lord.
So there is no material to show that sample was drawn properly or not.
Yes, my lord. So it was appreciated. And FSL, my lord, letter was not exhibited. Secondly, the letter which has been mentioned, there is no mention in respect of, my lord, batch number. Why I am harping on batch number? Because if the batch number is available in the sample, then they may argue same batch, my lord. Why it is necessary? Why that is why list of sample necessary. Despite of that, I argued before your lordship is there only one bottle has been sent.
Okay, that means your submission is to show that
Yes, ma'am.
it was the sample of the seized
Yes, ma'am.
contraband.
Yes, ma'am.
That it was sample.
Yes, ma'am.
Batch number is necessary.
Yes, my lord.
Unless batch number is there, we
Yes.
cannot,
Yes, my lord.
you cannot say that it is sample of that.
Yes, my lord.
That is your submission.
That is my submission, my lord. And law also said sample, why certificate is necessary. Law is not fact. Law said certificate is necessary. I have relying other judgment also, my lord. A Mohanlal should be followed, my lord, in Bothilal and Simaranjima, same type, my lord.
Okay.
And another judgment of our High Court, my lord, in respect of collecting the sample, my lord. Honorable Justice Malosri Nandi has passed an
Which
flag 8.
you have cited in
Yes, my lord. Flag 8.
flag A.
Yes, my lord. Vicky Pasori.
keep a chart
That's all.
like it.
জানে দিদে এখন আর প্রজেক্ট বলে দিলে কোথায় দিন তো Lordship, kindly come to the before para 16 Milo 2.4 that has been mentioned. 2.32 বলে দিন 2.3 Milo. Your Lordship, can you read para 15?
Yes.
2.3. The quantity to be done each sample for chemical test shall lay not less than 5 grams in respect of all narcotic drugs and psychotropic substance, even save in cases of opium, ganja, and saras, where quantity 24 gram in each case is required to be chemical test. The same quantity shall be taken for the duplicate sample also. There should be two samples. One is original sample, another is duplicate sample. The seized drug in the package container shall well be mixed to make homogeneous and represent sample before it's done. They can do all this. That was not done in the instant case, my lord. They mix it, my lord, homogeneous, my lord, that this is the sample, my lord. That was not done in the instant case, my lord. In the case, seizure of a single package container, one sample in a duplicate shall be done. Normally, it is advisable to draw one sample in duplicate from each package container in case of seizure more than one package container. That was not done in my case, my lord. There are 13 bottles, seized, only one bottle censored. Para 16. On the conjoint reading of both standing order number 1, 9, so number. In case of ganja quantity sample taken 24 gram for chemical testing, the said sample to be done duplicate. Said duplicate sample must be preserved, kept in safe custody of the investigating officer along with this case property. The honorable case in case of Simoranjing by State of Assam held a procedure of sampling prescribed under standing order must substantially comply with. Standing order which has been mentioned should be complied with. In case hand, there is no application made custom official for disposal of seized contraband under section 52A2 of to the jurisdictional magistrate. Here in the instant case, there is no certificate that it should be destroyed. No any application has been filed by the investigator for certification for correcting inventory photograph sample of the seized contraband and issue certificate under 52A. Third certificate is not available. I have a,
Chaudhary, you have to conclude within so that they can reply.
yes, my lord.
I don't want to keep it part.
I am completing my rest. What he will submit, I shall give reply. That is why I prepared the written argument. Everything I mentioned in the written, he can complete my. So my humble submission in this judgment has said, you have take from each bottle representative of sample, you can mix it and it can be sent to the FSL. That was not done in the instant case, man. Well, certificate is not available. And for the, I am only thing is that, my lord, there is only link and safe custody contraband. I have produced some judgment, my lord. If he argued on the, if you are not satisfied other point, my lord, then I'll argue with him. Yes, I will not argue.
No, this 89, one query.
Yes.
This notification 89 of,
Yes,
1
sir.
of 89, which speaks about sampling of opium, ganja and charas,
Yes, sir.
hashish. All are solid or semi-solid.
Yes, man.
How to take sample from liquid
My lord,
contraband?
how a humble submission as per
Included narcotic level 14 included.
one said that standing order 1. According to legislation letter, 1(6). I have where I have given notification. 14 is available.
14 is
Section 1, drugs mean for disposal.
where?
One notification I have.
Oh,
noticed,
yes,
and,
yes, yes. Okay.
6, number 6, 14.
No, this is regarding disposal. Regarding sampling 2.4, 2.
Section 2 deal with sampling, my lord. I want to satisfy submission before your lordship is that, my lord. When if suppose it is not available, I am not going to read this notification all, my lord. Suppose this is not available, my lord. Suppose, then my lord, spirit will be followed, my lord.
codeine has been mentioned here, disposal codeine. Suppose, my lord, there is a notification said you take the representative sample. You should, whether it is solid or liquid substance, my lord, we have to take the sample, my lord, from each bottle, my lord. That is my humble submission before your lordship, my lord. Otherwise, how can they presume that each bottle contain, my lord, cough syrup, my lord? They have taken one bottle out of 13, my lord. Yes, one. And if your lordship allow me go to the evidence, my lord. I am not reading evidence, my lord. If
Okay,
your lordship,
Mr. Borua,
yes, my lord.
Your-
Your lordship found it was recovered from the veranda. There are 4 or 5 people inside the house, my lord. How can my lord say, they said, my lord? He has a
Mr. Borua,
conscious possession of
their
that.
main contention is regarding sampling,
Yes.
that sampling was not proper as per the statutory provisions.
My lord.
And therefore, there is a question that whether it was the sample of the seized contraband or it is
Hello.
something else.
My lord, for that purpose, lordship will have to, my lord, go into exhibit P4, lordship.
Exhibit P,
P4, that I have flag mark, lordship. That is from the LCR, my lord. Lower court record.
inventory,
He was declared hostile.
exhibit P4.
Now, lordship, the investigating officer, lordship, my lord, he has filed an application, my lord, on 29/9/2021 for certification. That is exhibited as exhibit P5, lordship. That was filed before the, my lord, learned trial court, my lord. And the court had ordered dated 29/9/2021 passed an order certifying the correctness of the sample drawn, lordship. Now, if lordship will come to my lord, the order dated 29/9/2021, lordship. That is, I have flagged, lordship. That is the very first part of the my lord, LCR, lordship. Order dated 29/9/2021.
Yes.
Lordship will come to page 3, backside, my lord. My lord, that is, I am reading only paragraph 3, lordship, sub paragraph 3 of the page 3, backside of the page 3, my lordship. Further, for sampling of the says article, 100 ml bottle out of 13 bottle is of escape is taken as sample and keep it in a sealed condition in my presence. The rest of the 12 bottles are also kept in sealed condition in my presence. Hence, I hereby certify the correctness of the samples as drawn.
No, the submission, their submission is that as per 52A to C,
My lord.
there has to be a list of samples.
Yes, list of
Which
samples,
has
my
to
lord.
be
That is the
certified.
inventory, lordship. That
No,
is inventory, my
is
lord.
different thing.
Because, my lord, the contraband
You
is the
read-
same cough syrup, my lord. It's 13 bottles of
That-
escape cough syrup,
I don't know, that is the submission of Mr. Chaudhary,
my lord.
that 52A C
Yes,
provides for 3 things.
yes, it is, everything is correct and as per record, lordship.
3
I'll
things.
satisfy, lord.
And his submission, what I understand, is that last thing is missing.
Certificate is missing, my lord.
Certificate is
Yes,
missing.
certificate, lordship will find from exhibit P6. Lordship will kindly come to exhibit P6, lordship.
In that order also mentioned 2 certificates. There are 2 certificates.
Lordship will find is the photographs, P6,
Yes.
and just below the photograph, lordship will find a certificate.
What, read that certificate?
My lord, that certificate, my lord, the LCR is not before me, my lord, but there is a certificate, lordship, just before the, my lord.
The photograph
What
is
is-
taken.
Yes,
and
photograph
picture.
and below the photograph, this is the certificate. my
But
lord.
this is the certificate as regards photograph only. What I understand from his submission is that you have to certify the inventory first.
My
You
lord,
have to certify the photograph second. You have to certify the list of samples third. There has to be 3 certificates. That is his submission.
my lord,
So he says that in this case, there are only 2 certificates.
one certificate is missing.
And the list of samples, certifying the list of samples drawn
Yes.
is not there. That is his submission.
No, that for that purpose, Lordship, that order is clear, Lordship, 29/9/2021. This is very specific, Lordship. Further, for sampling of the seized article, 100 ml bottle out of 13 bottle escape is taken as sample and keep it in a sealed condition in my presence. That is a learned trial code, my lord. The rest of the 12 bottles are also kept in the sealed condition in my presence. Hence, I hereby certified the correctness of the samples so drawn, madam. That is reflected in the order, my lord.
So your submission is that mention in the order sheet
Is sufficient,
would
madam.
cover that.
Yes, madam, it is sufficient.
Okay.
My lord, his second point was that, my lord, the recovery was not from his possession, my lord.
But in this certification, batch number is not mentioned.
Batch number is not mentioned, probably, my lord, in the inventory, my lord, it is mentioned, my lord.
No,
inventory
not mentioned, as
Because, my lord, the 52A, my lord, 52A does not say, my lord, the batch number is required, my lord.
No, why certification is necessary? Sampling, why that?
Yes, my lord, my learned senior friend, he is submitting, my lord, that.
No,
She-
I want to understand
My lord.
why that certification is necessary.
Certi-
Why, when a sample is drawn
My
from
lord.
the contraband,
My lord.
why certification is necessary?
My lord, certificate probably necessary because the, my lord, the drugs are disposed of, my lord, after the, my lord, inventory.
No, perhaps it is necessary so that in the transit to FSL, there is no manipulation.
Yes,
Perhaps
yes, my lord.
that
That is also true, my lord. Yes.
instead of sending the said sample, the police may send some other sample.
Some sample, my lord. Yes.
So-
That is- yes.
The FSL has to mention that this is the sample which we have received
My lord.
and this we have examined, and in this sample we have found this
This
contraband.
is contraband. Yes, lord will be absolutely correct, my lord.
Perhaps.
Yes,
So if that certification is not there,
my lord.
their fear that the requirement of 52AC last requirement is not followed. Your submission is that if there is a mention in the order sheet, it is sufficient.
Yes, but because this is a judicial order, my lord, that has been mentioned specifically.
Okay.
And my lord, I'll just take your lordship to 52A4, lordship.
Yes.
52A4, notwithstanding anything contained in the in the Indian Evidence Act 1872 or the Code of Criminal Procedure 1973, every court trying an offence under this act shall treat the inventory, the photographs of the drugs, the psychotropic substance, controlled substance or conveyances, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offence, my lord. These are the evidence, lordship, that this contraband was recovered from his possession. It was, my lord, inventory was prepared, that was certified. Then FSL, it was sent for FSL. FSL report said is codeine, positive for codeine phosphate, my lord. And moreover, lordship, the contraband, it was recovered from the house of the accused person, lordship.
Okay.
My lord, regarding, my lord, his other submission was that, my lord, it was not, my lord, produced in the court or exhibited in the court, but that is not, perhaps not necessary, my lord, as per section 52, my lord. Because the 52 says, my lord, I am not reading, my lord, everything, my lord. The class of controlled substance or conveyances which shall, as soon as may be after their seizure, be disposed of by such officer and in such manner as that government may from time to time determine after following the procedure herein after specified. But that is, my lord,
Physical production is not
not
necessary.
necessary, my lord. That is why, my lord, the photographs and certificate is necessary.
52A4 compensate that.
Compensate.
52A4
4, my lord.
that the certification would be treated as
As the
primary.
primary evidence before at the time of trial.
Okay.
Now, lordship, I'll take your lordship to my lord. My learned friend has already read the evidence, lordship. He has said, lordship, PW 1 and 2 has not
No, one more thing he has mentioned that the batch number of the batch
my lord.
from which the sole bottle of the sample
My
which
lord.
was sent belongs to was not mentioned.
Not mentioned.
How
That
to
is-
ascertain that other 12 bottles also contain the same?
My lord, for that purpose, what the certificate is, my lord. That is sufficient, lordship, because certificate it is certified by the
Which certificate?
my lord, the inventory and the other certificate, lordship.
No, other certificate is not there. Other
No,
certificate
Other
is
certificate,
only
lordship, I'll only, my lord, draw your attention to exhibit P4 and P6, lordship.
P6 is the photographs.
Photographs and the certificate, my lord, these are the copies of my lord. Because there is no such evidence there and there is no, my lord, any adverse, my lord, evidence that it was not the same bottle, lordship. If there is any adverse evidence that, my lord, all the bottles are different, my lord. Because as far as Caesar is, the 13 bottle of Escaf cough syrup.
So even if there is no mention about batch number,
Best number, my lord, it will not, my
it
lord,
would not affect your
affect
case.
the, my lord, prosecution case, my lord. My lord, I'm just reading the, my lord, the paragraph 16 of the judgment, my lord.
16 of which judgment?
Paragraph
Into-
16 of the judgment, my lord, the page number is, my lord, 28, my lord. I'm sorry, lordship, 29, my lord. Of the memo of appeal, my lord. Paragraph, page number 29 of the memo of appeal. Page 29. Appeal form.
Yes. Page?
Page number 29, lordship. Of the memo of appeal.
Yes,
May I read, lordship?
yes.
In view of law and appraisal of evidence on record, this court is
Page
of
29, which para you, where?
paragraph 16, lordship. Paragraph 16. এটা আপনার পৰা পঢ়িছো, আপুনি দিয়া বস্তু।
Para 16 is not there in page 20.
My lord, in my petition, my lord, it is 29, my lord. It was some.
Page
No,
30.
anyway, lordship will come to page number 6, paragraph number 16 of the judgment, my lord.
Para 30, yes,
Para
in view
16.
of the law.
In view of law, the appraisal of evidence on record, this court is of the view that when recovery was proved from exclusive and conscious possession of the accused, there was no merit in arguments that the accused was falsely implicated. Prosecution has proved guilty of the accused conclusively beyond all reasonable doubts. Accordingly, the accused Monirud Zaman is convicted for commission of offence punishable under section 21C of the NDPS Act. Now, my lord, next paragraph 19, lordship.
No, what you want to show from this paragraph?
My lord, that is, my lord, this is recovery was from the exclusive possession by the, my lord, accused person, lordship.
That
And
was the
PW 1 and 2, lordship, in their evidence, they have stated. That is reflected from the, my lord, judgment paragraph. My lord, I am just referring to the paragraph of the judgment, my lord. That is decision and reasons, paragraph 6 of the judgment, my lord.
Okay. Yes.
Taking note of the aforesaid points and considering the rival strength of the parties, I have made a thorough visit of the evidence on record. Out of the 6 witnesses that have been examined by the prosecution side, in this case to prove the case against the accused, the PW1 and PW2 are the witnesses in presence of whom the OC of Moirabari PS along with other police personnel conducted search in the residence of the accused and seized 13 bottles of Escap cough syrup from his possession. The relevant fact that the PW1 stated during his evidence were that on 28/9/2021 at about 3 AM, police personnel from Moirabari PS called him to the residence of the accused Monirud Zaman. Accordingly, within 5 to 7 minutes, he rushed to the spot and noticed that the police of Moirabari PS were standing outside the house of the accused Monirud Zaman. In his presence, the police knocked the door of the house of the accused Monirud Zaman and the accused came out. police searched the residence of the accused and recovered some expired medicine and cough syrup bottles. The PW1 exhibited the seizure list in the court as Exhibit P1 and his signature on the exhibit seizure list as Exhibit P11. He further stated that during investigation, he was interrogated by police. He also stated that in his evidence that at that time, he was the village headman of Goroibari Pathar, where the accused was also resided, my lord. So these are the evidence, my lord, wherein the recovery was made from the house of the accused, my lord. It was his conscious possession, my lord.
Okay, but somewhere in his cross-examination, he has stated that
Yes, my lord.
Yes.
he,
No, let me complete. Lordship. Then what is the finding of the, my lord? What the finding of the trial court, lordship?
In judgment, it was not discussed on proper perspective.
Yes,
my lord.
yes.
If your lordship go PW1 and 2, your lordship have
somewhere
different
he
evidence.
has stated that I cannot say for sure that it was a cough syrup.
So witness, my lord, witness, they are the, my lord, seizure witness, my lord.
PW1, 2.
They may not, my lord, they have only seen the bottles of cough syrup, my lord. Well, whether it is a cough syrup or not, my lord, they will definitely, but the normal person will definitely not know, lord.
So only the statement of oral evidence or oral testimony of PWs are not sufficient.
My oral evidence of the PW1 and 2 are sufficient vis-a-vis the seizure list, lordship. Because seizure made from the possession of seizure made from the accused person, lordship. And as per this finding, mercy, para 19 of the judgment, my lord. Because my learned friend here denied that, my lord, it was not seized from his possession, lordship. That findings, my lord, that paragraph 9 of the judgment, my lord. In paragraph 19 of the judgment. There is no evidence forthcoming in this case that the accused Monirud Zaman knowingly permitting his house to be used by another person for committing any offense. Plainly, the accused did not permit any other person to use the house for committing the said offense. He illegally kept the contraband concealed in his house. There is no evidence at all permitting his house to someone else or used for commission of said offense. Accordingly, he is acquitted from the charge of section 25, my lord. 25 he was acquitted, my lord. But regarding, my lord, conscious possession, my lord, this is the finding of the trial court at page 19. Sorry, paragraph 19, my lord.
Yes.
So, this is my humble submission, lordship.
Anything in reply?
Appeal is liable to be dismissed, my lord.
Humble submission before your lordship, I have already read PW1, my lord. After looking to the, he is not, my lord, simple man. He is a Gaura, my lord, of that locality. Gaura, no? He is a Gaura. After looking to the bottle, he said it is a suspected narcotic drugs. That was not mentioned. He said, simply, he said that I cannot say that expired medicine were cough syrup bottle or not. That is evident. That evidence go in my favor. My duty is to prove preponderance probability. Their duty to prove beyond all reasonable doubt, my lord. How can they say it, my lord? It is a conscious possession from me, my lord. And PW3. And next, what point? PW2, your lordship, look. His evidence. His evidence. PW2 in this evidence is stated, my lord.
Yes.
I'm reading that, your lordship will look later on, my lord. The residents of accused Monirud Zaman recovers various medicine-like articles. Some of them keep in a honey bag on the veranda of the house. How can they say it is a cough syrup, my lord? Who said? There must be some evidence. That is the evidence of the court, my lord, before the court, my lord. And I have seen one bag on the outside of veranda only. And PW3.
I did not note number.
Yes, my lord. PW3 in his cross said I did not note about the number of person living in the house where from cough syrup bottle were recovered. I did not obtain any signature of the seizure witnesses. He has not obtained the signature of seizure for keeping the seizure of Malkhana register. That was not produced, my lord. No one has said, my lord, that it is a contraband, is a seized contraband, my lord. PW 1 and 2 has not said it is a, my lord, psychotropic substance, my lord. That is my humble submission. And the whole case is based on PW 1 and 2. PW 3 is the police officer, my lord. And another important thing is that I forgot, my lord. Whole case was made on the basis of GDNT, my lord. And that GDNT was not exhibited in this case, my lord. There is a judgment, Debu Munda, my lord. Citation I have forgot, my lord. That you have to produce that GDNT. Otherwise, whole prosecution case will be demolished. And in respect of my lord seizure list, I am not wasting time of the court, my lord. In respect of seizure list, here they have categorically mentioned it was seized on 2:45 PM, my lord. If it is 2:45 PM, my lord, it is afternoon, my lord. And incident took place, my lord, in the intervening night, my lord. And one judgment, my lord, I will not read, my lord. You will also kindly look, my lord. In respect of my lord, not producing, my lord, Malkhana register, my lord. That is, my lord, para 21, my lord. Muhammad Khalid, recently 2024, SSC online, SC 213, recently come, my lord. Serial number, my lord, 11 or 21. Serial number 11 judgment, my lord. Serial number 11 judgment, para 21, my lord. I read, my lord, small judgment. Sub Inspector LW10, who prepared 3 samples of ganja as per testimony of PW5 not examined in evidence. In addition to the prosecution, neither examined any witness nor produced any document to satisfy the court regarding the safe keeping of custody sample right to time till the time is reached to the FSL. The official who collected the sample from the police station and carried to the same FSL not examined trial from the quoted prosecution evidence seizure officer, it is clear as daylight that he handed over 3 samples to the accused. The witness admitted that he did not mention about the sealing of sample Panchanama contrary to the evidence stated their sample. In cross-examination, the witness admitted that he did not file any document to show that property was kept in Malkhana. They have not produced any documents to show the property was kept in Malkhana. In this case, particular case, the Malkhana register was not produced before the court. Here also, my lord.
No, if it is not produced, how it affects you?
Yes, my lord. That is important, my lord. Your lordship has how I was prejudiced if it is not produced.
Yes.
Because, my lord, two witness, PW1, PW2, both are my lord seizure witness. They never said it is a psychotropic substance, my lord. Your lordship may be recorded in my statement, my lord. Then, the where from that were to whom the Malkhana, it was, my lord, delivered. That was not mentioned. Malkhana register not produced. It was sent on 28, it was kept in the Malkhana. 29, it was produced before the court. Between this period, from seizure and to that, where is that? There is no link of evidence, my lord. To that link of evidence, I have given some judgment, my lord, in my written argument also. Your lordship will find. If this link is not available, my lord, how can they prove? And more particularly, PW6 has said it is a heroin. Where from heroin come, my lord? In criminal case, everything should be proved beyond all reasonable doubt and everything should be done under the statute. In respect of certificate, my lord, just now I got, my lord, that certificate itself is a wrong, my lord. As per, my lord, exhibit, my lord. I am not reading, my lord. I give only number for number to listen. GSR 38E dated 16 January 2005, page 223 in my book mentioned, my lord. 2015, my lord. It was as per, my lord, GSR 38E 16 January 2020, my lord, they mention how they will take in. There is a list, my lord. How the, my lord, magistrate will certify. That will find your lordship in page number 228, my lord. Annex T, no, sorry. That my lord certificate by the magistrate under subsection T 52 a narcotic and psychotropic substance. I allowed the application under.
Format is given.
My lord?
Certificate
Yes,
format.
my lord. Format, that certificate was not followed in this case, my lord. Your lordship will verify. This is-
Format of list of sample, certificate regarding list of sample is also given.
Order to the passport.
That order has been passed in respect of sample also, my lord. And list of sample not available. That is I undo separately. In respect of certificate which has been given in the inventories, that is also wrong. As per this book. Certificate, the magistrate subsection 3 of 52A Narcotic the Psycho Substance Act. The magistrate, that magistrate order, that itself is a wrong, my lord. As per this. Page 1 of this. This should be in this format, my lord. Page 298, my lord. Annex K, certificate of the destruction before that, my lord. Certificate by the magistrate under subsection 52A narcotic the psycho substance. That is my additional argument. My humble certificate is mandatory in respect of keeping Malkhana. That is not proved beyond all reasonable. Seizure was not proved beyond all reasonable doubt, my lord. That it was recovered from the conscious possession of the petitioner, my lord. Everything has been beneficiated. And all over, my lord, I am already behind the bar for 2 years, 8 months, my lord, nearly 3 years for 13 bottles of cough syrup, my lord.
No, that submission will not help you.
10 bottles
Not-
become commercial, lordship. So 13 bottles, let's say 10 plus 3, my lord.
My humble submission before your lordship is that, my lord,
Okay.
in respect of
Okay.
harassing, my lord, if your lordship follows the harassing, my lord, that is, then we cannot, my lord, perform Sivarotri, man. Uta cannot be taken, my lord, because it is a commercial content, my lord. And that was, my lord, distinguished in judgment in Delhi High Court, but that judgment is not available, my lord. In Delhi High Court,
No,
this judgment has been
You
distinguished.
perform Shivratri with bhang.
Yes, sir.
Whether bhang is prohibited.
There is a, my lord,
Ganja is prohibited.
there is a one part is not, one part is now judgment has come, my lord. In respect of ganja, I forgot that particular line, my lord. That is not prohibited, my lord. That ganja, that part, my lord.
Only flowering top of
Of
the
firing top
cannabis
is
is
prohibited.
prohibited.
Other part is not prohibited.
You perform your Shivratri with other part.
Yes, my lord. No, my lord, I am not. taking
Mr. Borua,
this thing, my lord.
My lord.
regarding the testimony of PW6,
My lord.
that he said that heroin was found.
My lord,
You
this is the evidence of the investigating officer, lordship. My lord, he has said,
No,
lordship.
what is your submission?
No,
Just-
my submission is that the record will say, lordship, the FSL report will say. it
So
is a
we have to
protein.
rely the FSL report.
FSL report,
not
lordship,
the
because,
oral
my lord, there is a minor discrepancy, lordship. That is, my lord. Probably, my lord, that is mentioned in one of the judgment.
My humble submission before your lordship is that, my lord, report is a suggestive evidence. The ocular evidence is the main evidence, my lord. There is a judgment.
My lord, that is reflected by the paragraph 15 of the judgment, my lord, in this appeal, my lord.
And
Paragraph
impugn
15, my lord.
judgment has dealt with that issue,
Yes,
that
it-
discrepancy.
Yes, it is there, my lord. It is well settled in law that minor discrepancies are not to be given undue emphasis. And evidence is to be considered from point of view of trustworthiness. Test is whether the same inspired confidence in mind of the court, my lord. But the court will definitely go by the FSL report, lordship.
Okay.
How can he say, my lord, the main IO?
Regarding notice the
Who
GD and
has
trail, lordship.
exhibited? He has said, my lord.
Regarding GD and trail, lordship, what my landed has submitted, my lord, even my lord, as part of my lord, Colonel Singh, my lord, Colonel Singh for the state of Haryana. It is 2009 8 5, page 539, lordship. Without mentioning the GD entry also, lordship, without writing down the GD entry also, my lord, investigation can be, my lord, initiated, my lord. That is, my lord, paragraph 35, my lord. Though the writing down information on the receipt of it should be normally proceeded the search and seizure by the officer. In exceptional circumstances that warrant immediate and expedient action, the information shall be written down later along with the reasons for the delay, my lord. The current thing is very much clear, lordship, in exceptional circumstances. Without even writing down the, my lord, DD entry also, my lord, they can proceed, my lord. There's a 5,000 bench, my lord, currency.
Heard Mr. NNB Chaudhary, learned counsel for the appellants. Also heard Mr. R. Borua, R.J. Borua, learned additional public prosecutor. Hearing concluded, judgment reserved.
Much of them.
Baki left over.
I shall give that certificate, my lord, photocopy of that, my lord.
So
Please, ma'am. Did you photocopy? One.
Lordship, item 42, Lordship.
other matters will be left over.
Lordship, here, I have a small prayer. Item 42 is come for hearing. There is a IA pending, Lordship, 928.
Perhaps similar to this case which we have dealt. Now, what is your submission?
My prayer that IA be listed, Lordship, in the whenever next week or
2023 matters.
23 years. IA 928/2023.
Whether the case has been admitted,
Yes, it is admitted.
then you have to make prayer before registry.
May I please, your lordship, I have a small prayer, my lordship, regarding the item number 16, my lord. The petitioner was arrested, my lord. I may be allowed to do this petition, my lord.
Withdraw.
Yes, my lord.
Heard Mr.
F.A. Hassan on behalf of P. Ahmed.
F.A. Hassan submitting on behalf of Mr. P. Ahmed,
Ahmed.
learned counsel for the petitioner, who submits that as the petitioner has already been arrested, this anticipatory bail application has become infructuous. And therefore prays for allowing the petitioner to withdraw the same. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.